Good evening. I call the February 13th, 2008 meeting of the Los Gatos Planning Commission to order. I'm Joanne Talasfor, Chair of the Planning Commission, and I and my fellow commissioners welcome you here. The Planning Commission is composed of citizens appointed by the Town Council to review planning and development issues and to make decisions and recommendations to the Town Council regarding land use, both for commercial and residential matters. As we hear discussion tonight, we will consider each proposal, and our actions will be guided by the town's general plan and other zoning codes and policies and standards that have been adopted by the Town Council. Thank you for attending tonight's meeting. We do appreciate public testimony as we evaluate each matter. And as a reminder, would you please silence your cell phones for tonight's meeting? And with that, Mr. Tsuda, would you please take roll?
Commissioner Michichi.
Oh. No.
Commissioner Bourgeois.
Here.
Commissioner Rice.
Here.
Commissioner Sayoc.
Here.
Commissioner O'Donnell.
Here.
Vice Chair Kane.
Here.
Chair Talasfor.
Here. And with that, Commissioner Rice, would you please lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, I'm looking for approval of minutes, Commissioners, and those would be of January 23rd, 2008. I have a motion from Commissioner Kane. Do I have a second? Second. And second from Commissioner Sayoc, who beat you just by 1/30th of a second, Commissioner Michichi. So all in favor, say aye.
Aye.
Aye. Opposed? None.
And I'll abstain.
And thank you. So we have six in favor of approval with one abstention, which is Mr. Rice. We have no communications, but we do have two desk items tonight for item number 2 and item number 3. So Commissioners, when you have a minute, we'll take some time during those hearings to have you read them. No written communications, but we do have a requested continuance for tonight, and I will need a motion on this, Commissioners. It's item number 3, and it's application S-07-201 at 15451 Francis Oaks Way. The applicant is Tony Rivellini. Property owners are Owen and Diana Nolan. The appellant, we have two appellants in this case. Appellant number 1 is Owen and Diana Nolan for continuance of this to March 12th, and appellant number 2 is David Weissman against the continuance to March 12th. The continuance is an appeal for Development Review Committee's decision to approve a grading and drainage plan for previously unauthorized grading on property zoned HR1, APN number 527-10-010. The recommendation from staff is to continue to March 12th. So I will take some discussion now. About that. Commissioner O'Donnell.
I just have a question.
Yes.
I assume the person, at least the person opposing it, is here tonight, and perhaps the person asking for it. Should we hear anything from them or not?
Should they be here tonight? Is that what you said?
No.
Tell
But
me.
what I said is if they are here tonight,
Yes.
should we listen to their request? We've read the written request and the written opposition, but if they're here, I'm just wondering if you should afford them the opportunity to say anything.
That's a good question. I would think that perhaps we could. I don't know. I'll go to Mr. Korb. Do you have a comment on that?
Well, you can and have in the past opened the public hearing to take comment from those who are present and then continue the item to a date certain. That is an option. I might as well take the opportunity right now to address a further issue with regard to this matter. I've reviewed this report, and I've also reviewed the provisions of the code concerning the imposition of penalties for grading violations. So when this matter is heard, whether it be now or later, my advice to the commission would be to deny both appeals, but to modify the condition of approval to remove the amount of the penalty and just merely state that the applicant shall pay any penalties imposed. And the reason for that, and I'll state this later if necessary again, but the reason for that is because the code does not provide authority for staff to unilaterally impose any penalties, nor does it provide any authority for the commission to impose or to decide on the amount of any penalties for a grading violation. What the code does say, in the provision that one of the appellants, Dr. Weissman, referred to, but in a slightly different context than his discussion, what the code does say is that I am authorized on behalf of the town to initiate a civil action to enforce any violation of the code, and the court is authorized under the provision of the town code to impose penalties up to the amount stated in the code based on any of the facts and circumstances that the code suggests be considered with regard to any potential violations. There is nothing in the code that provides a unilateral authority on behalf of either the staff or the Planning Commission to impose a penalty. I do think it's possible to agree administratively to the settlement of a code violation, and that settlement can include the imposition of a penalty, but I don't believe that that can be done unilaterally. So based on the fact that I don't think that there's authority in the code either for the action that was taken or for the action that's requested through this appeal of the Planning Commission, again, my recommendation will ultimately be to deny the appeals and remove the dollar amount and leave it to staff to work with the property owner to determine the appropriate penalty for the violation. And if no agreement can be reached, then if staff does refer this matter to me, then I can avail the town of the authority under the code to initiate a civil action.
Okay, thank you. Do we have a follow-up question, and then Commissioner Kane has a question?
That being the case, I think both appellants at least should consider tonight whether they want to continue. One wanted to continue it so Mr. Rosti could be here, which is fine. It's certainly a right. But since we're all learning something this evening, i.e. that there will be no penalty imposed by us or sustaining a penalty already imposed, they may or may not wish to continue it. As I read it, the only objection I saw was to the penalty. So I just think it should be clear to the two appellants that that's where we are, and then we could listen to them to see if one of them still wants that continuance.
Okay. Commissioner Kane?
To the council,
Yes.
Madam Chair. Mr. Korb, so what then is the avenue of redress? If we deny the appeals, can they be appealed to council? Is that what you're saying?
Well, yeah. I mean, they do have a valid appeal before the Planning Commission, and if you deny the appeals, as I would recommend that you do, then they still have the right to appeal to the council, and I would give the same advice to the town council.
To do what?
To deny the appeal, because the authority doesn't exist in the code.
Spell out for me then, where is that authority? With council? I mean, with you? With
no.
the attorney?
You mean the authority to impose a penalty? In the town code, I am authorized to initiate a civil enforcement action in court, and the court is authorized to impose a penalty should the court find the violation, and should the court consider a penalty appropriate given the facts and circumstances laid out in the town code. And if you need a reference to the section, it is section 12.40.035. As I said before, we have a code enforcement operation. We deal with penalties every day. Code enforcement's primary goal is to resolve violations. It is possible to administratively settle a violation by coming to agreement with regard to the mitigation for any violation and a penalty. And anybody who thinks that the code enforcement operation of the town in any context, whether it be a grading violation or any other type of violation under the town code, is not being sufficiently prosecuted by staff can always complain to the manager or complain to the town council about whether, or even to this body about whether it's being done appropriately. But ultimately, it's up to the manager to deal with enforcement issues and the council to deal with policy issues.
Well, my point may be much ado about nothing, because we see such a case as this once every 1 or maybe 2 years. And on those occasions, you have weighted in that it might not be an item of jurisdiction for the Planning Commission. So when I received the staff report, I went through it word by word, looking for, well, it's coming to you, but you don't have any jurisdiction. I didn't find it. So I spent a lot of time on Dr. Weissman's brilliant letter, brilliant in argument and rhetoric. I don't know about in fact, but he gave 85 code references. I checked them out. I did my homework, and if that was time not well spent, we might want to provide us with something that in the future can clarify, not only for us, but for appellants, Dr. Weissman and Mr. Rossi, that this isn't something that needs to come before us or that we need to spend time on. Because the Weissman letter, as you know, is huge in its scope and makes a lot of seemingly fine points, and that's what I prepared tonight's case on.
I'm not in any way suggesting that the factual presentation made by any of the appellants is in any way in error or incredible in any way, shape, or form. That's not my concern at this moment. Those are facts that have to be considered by the body with the authority to make a determination with regard to a penalty.
I need to make sure I'm making my point.
I don't believe that is the Planning Commission.
We didn't know that this weekend, and that's where I spent much of my time, was in preparation for this case because of that expansive letter. And if we ought not to have done that, then we can clarify in the future that we need to stay out of this area.
I'm clarifying that right now. And the issue that we've dealt with in the past with regard to violations has been the situation where a violation occurs, a subsequent corrective application is made to the Planning Commission, and the council in those situations has directed the commission to deal with the merits of those applications, not with the issue of the prior violation. So we haven't been dealing with penalties in those situations. We've only been dealing with subsequent applications after a penalty has been found and an effort has been made to correct that violation.
Do I have any other questions? So that being said, what this means right now is, did you still, Commissioner O'Donnell, would you still want to,
I think it's important that we find out whether the people asking for a continuance in light of what I consider to be good advice by the town attorney really want the continuance, because what I'm hearing is we're no longer dealing with the penalty. We aren't. The town may be, but it's got nothing to do with tonight's proceeding. My understanding of the request for continuance, and I may be wrong, was because of the penalty, they felt they should bring in an attorney, which is fine with me. But if, on the other hand, they're saying, oh, well, that's good news, we don't need a continuance, we at least ought to hear from them. That's all I'm saying.
No, I would want to do that.
And I should also say, this is a public hearing. Whether you hear it now or later, they do have the right to testify. So proceeding has to occur.
Would the commission want to have some testimony at this point about whether they would like to continue or not? Okay, then why don't we, Commissioner Minchichi, yes? What?
I said in light of that information, there's no need to continue. If they're here, we may as well have the hearing tonight.
Pardon me, Commissioner O'Donnell? What did you say? Yeah, okay. So I will open the public hearing right now just for, do I have both parties here? That would be Mr. and Mrs. Nolan and Mr. Weissman. Okay. Mr. Tell me, okay, Brevellini. Who would be speaking? Sir, I'm going to open it just for this. You can let us know if you'd like to continue. Pardon me? Mr. Rossi? Okay.
I'm with Mr. Ross's office.
Okay, all right. So whoever's going to speak, would you please, I'll let you speak first and then followed by Mr. Weissman. And you will have, I guess, 5 minutes or 3 minutes? 3 minutes, I think. This isn't the actual hearing. This is going to be to the issue of whether you would like this continued or not.
And with that, I don't even think
You
I'll
get
take,
3 minutes.
I don't even think I'll take the 3 minutes.
Okay, would you state your name, please?
My name is Eric Gravink, spelled Gravink. I'm one of Mr. Rossi's associates. He asked me to come down here because he couldn't come here personally. The limited knowledge I have about this file, and the reason we request a continuance is, one, we just got the file. We requested a continuance last week. It's the first request for continuance. Given the gravity and the issues, even the issues that are raised tonight, I think a continuance is appropriate, so we can all just kind of figure out what Mr. Korb had to say. And with respect to the penalties, if you look at the staff recommendation, the monetary value that they recommended was based on the tree mitigation as well. So there's kind of more of a component in the recommendations for the remediation and the issues with the stop notice than just the money. The two were linked together in the document. And just out of all fairness to the Nolans and Mr. Rossi, we just need some time to get the town council file, which was pulled for this hearing, so we don't have access to that as of yet, and to sort through the information. And all we're asking for is a short continuance. The Nolans are really the party that has the most prejudice if we move forward. I understand Mr. Weissman's concern, but he's not the one with the sanctions or the potential violations being imposed, and his property is not the one with the direct impact, although I understand his concerns as a neighborhood, as a neighbor and things, but he's not directly impacted. So given those issues, given Mr. Rossi's unavailability, we just respectfully request the short continuance that we've requested. And it's a first request.
And that continuance was to March 12th.
Yes.
Do I have any questions from the commission for the speaker? None? Okay.
Yeah, I have a question, because
Okay,
I'll ask-
Commissioner Machiti.
What do you see the purpose of a continuance is if we can't rule on the amount, or, I mean, what would be the purpose? And I'm hearing we're being recommended to deny it in any event, because the town would have to take action through the courts, through a civil action, so we can't do anything. Why would we continue it to not do anything later?
Well, my understanding, again, I have a very limited understanding because literally this thing just got dropped on us, is that there was more to the appeal of the decision than just the monetary portion of it. So we just need time to digest what all is involved and what is impacted, what is going to be affected by the denial besides just that monetary component that obviously we need to negotiate with the town.
I'll direct my question to
Okay.
Mr. Korb then, is my next one. Am I not seeing something here, Mr. Korb, or can you enlighten me?
Well, I can't see the world through your eyes, so I don't know exactly what you're seeing, and I say that with all due respect. What I'm hearing from this appellant is that they're not prepared to go forward. They don't fully understand all of the circumstances of the report and the penalty assessment. They need more time to digest what's there and to understand what I'm talking about. Under those circumstances, it sounds as though a continuance is in order, even though I'm guessing that when push comes to shove, they're going to probably say, we understand what the advice I've given to the commission is all about.
Okay, thank you. And Commissioner O'Donnell?
This question, again, really to the chair or to the council. We have two appeals.
Yes.
We have one party not asking for continuance. That party has appealed on the basis that the town codes were not followed in the penalty phase. Penalties assessed were not consistent with the infraction. I mean, we can rule on that tonight. He's not asking for continuance. It seems to me, therefore, we have two appeals. We could grant or deny one appeal tonight, and we could also, if the commission were so disposed, continue the other appeal. So I just want to throw that out. I mean, the one appeal is on the basis that the penalty's not enough, and I've just heard, and I have no reason to dispute it, that it doesn't make any difference what the penalty is. We haven't got a power to do that. So if that's the case, I don't know any reason why we should cause the appellant there to linger on that decision.
Madam Chair?
Yes.
Just one point in response to that comment. That's a valid point. I mean, you certainly can decide on one of the appeals, essentially split the appeals if you wish to do so. The only problem we have, of course, there is thereafter, once you make a decision on any one appeal, then it's subject to appeal to the council. There's a time limit, of course, for doing so, and there's also a time limit for setting a hearing, and we almost invariably get somewhat bollocksed up when we have applications split that are still going on to the council, because then we have two separate dates. So if it was our preference that you would follow, it would be to keep them together.
Well, let me make one suggestion. Why don't we go to the other side and see what they want to do, and then
Well,
we can talk.
I would like to do that, and anyway, do we have any other questions? Thank you very much. Mr. Weissman?
Dave Weissman, Francis Oaks Way. Interesting. This whole issue starts back a good 10 years, just to put things in perspective. In the last 10 years on Francis Oaks Way, there have been 10 separate violations for grading and tree protection ordinances from about 7 different lots on my street, and you've already got that in your packet. In the past, the town's, I think, application of the town codes and subsequent penalties and remediations have in many cases been inadequate. The developers, the homeowners up there know what they need to say to placate everybody, and because of lack of follow-up in many cases by staff, these penalties, these infractions have gone unenforced. This particular situation started out at a DRC meeting and therefore became appealable. And my whole purpose in this is to try to make everybody's job in the town easier by finally imposing the penalties that can be imposed given the town codes. It's my distinct impression that when the town got my letter on Thursday morning, Thursday at noon being the deadline for this information to be included in the packet, this information then got to the Nolans or to their attorney, and at that point they went, whoa, we're not ready for this. There is no town documents to review. There is no packet with these infractions and the ability to follow what's happened. Most of this, the deliberations between staff has probably been done by email. There is no file. I believe that, and I don't know this for sure, but that the attorneys were contacted probably on Thursday morning and asked for an appeal, asked for a delay because they simply weren't ready and the Nolans didn't anticipate these sorts of issues. There are two issues here. There's the grading from '04. There's the tree removal, the 2 trees dying in '07. The town codes are very specific about the tree removals. And the whole way staff is handling these two issues is confusing. They're dealing with the grading as the issue that the Nolans are appealing. The tree removal is somehow buried in there.
Mr. Weissman,
Yes.
records, bell sounded, so I'm going to stop you there, and we get the impression that you're ready to go ahead, move forward
ready.
tonight. Thank you.
There's no reason to delay.
I don't know that we have questions oh, you do? Okay, so Commissioner O'Donnell?
Is it clear to you that if we follow the town attorney's advice, no matter whether we totally agree with you or not, we are not in a position to impose a penalty at all? In other words, let me just finish by saying this. He has told us, and this puts this in my question, that the town can do something. They can bring a civil action to a superior, I guess a superior court judge. We can't do anything. So if we all agree with you, what do you expect us to do?
I believe Mr. Korb is referring to the grading violations. My understanding from reading the tree protection ordinance is that those penalties can be imposed by staff. And the tree protection ordinance is very specific. There are subsections B, C, and D.
Why don't we try to get the town attorney then to clarify his point, which is that really there are two things being appealed from. One you've commented on, which is the $10,000 penalty. Have you commented, or did you intend to comment, on the tree penalty?
I have not, and I will also add that staff will have some response as to whether there even has been a violation of the tree ordinance in their opinion. But again, that's the merits of the issue, and I think you've got a request for a continuance at this point in time.
But I don't understand your position. Are you telling us that if we did tonight find that there was a violation of the tree ordinance, we could or could not do something about it?
I have to refer to the code, but I don't believe that you have the authority to impose penalties on any violation of the code.
Would that include requiring him to replant trees?
You can require replanting trees. That's oftentimes part of a landscaping plan, but to impose monetary penalties, I think, is completely inappropriate and is not provided for anywhere in the code.
Okay, well, as I understand it, then we could do something tonight.
Mr. Korb, you're saying the tree protection ordinance does not provide for imposing penalties?
I've been looking at the grading ordinance. That's my primary concern, because my understanding of the $10,000 penalty assessment was that it was oriented towards the grading violation alone. So I'll have to take a look at the tree protection ordinance, but I am virtually certain that the Planning Commission does not have the authority to levy penalties.
And if staff impose penalties from the tree protection ordinance, might those be appealable?
Through the chair, because I don't want to be answering questions off the cuff. Let's put it that way.
I would like it just to be about the continuance, and so if the answer to this question is going to be about that, Mr. Korb, is that how you read this question? That this would help us with either continuing this matter or not, the answer to his question?
I think a continuance will help answer all questions.
Thank you. Do we have any other questions of the speaker? Commissioner Sayok, you did have your hand up. Do you want to withdraw?
I do have a question for our legal counsel.
Okay.
When he's ready.
In just a minute. We have a question for you.
Mr. Korb, I understand that in terms of enforcement, that resides with you, but as part of the administrative record and through the evidence that's presented to us, can we provide a recommendation? So that is part of your evidence as you're determining how to proceed?
No, I don't think so.
Well, I mean, you do have an appeal before you. I don't think I can keep you from making a recommendation as a consequence of this appeal. I'm saying that in the normal course, it should not be a question submitted to the Planning Commission regarding the appropriate penalty to impose for any violations of the town code. But in this proceeding, you know, I assume you're going to have comments, and I will certainly listen to what your comments are. But again, I don't have the authority on my own to impose a penalty either. I can make a recommendation for a settlement if that can be mutually agreed, but I cannot unilaterally impose a penalty. All I can do is bring an action.
Okay. I don't think, does anyone have more questions of the speaker?
No.
Pertaining to the continuance?
No.
Okay. Thank you, Commissioner Kane.
I have to put this in the form.
Pertaining to the continuance.
I'll put this in the form of a question. Did you know that I want to thank you for your level of engagement? Your letter made me do a number of hours I don't know where we're going to go in terms of our decision authority. But I compliment you and wish other citizens could get as engaged, as familiar with the codes, regardless of their position on what side of the argument. So thanks for your time and effort.
You're welcome.
Thank you for your question. Anyway, thank you, Mr. Wiseman. I think that's all for now. Commissioners, I'm going to turn this over to you, but my feeling at this point is that we have two parties here that are not in agreement about what, one of them is clearly not ready to proceed with anything tonight. It didn't seem to me. And the other one is fully ready. And I don't think that's fair playing ground here. So my feeling is that we need to continue this, and it seems to be a recommendation from the staff as well. And I don't think there's any...
Since we opened the public hearing, though, we only have...
Oh, I'm sorry. Yes, let me close. Pardon me?
Before you close it?
Yes, what?
Or are you going to close the meeting?
I'm going to.
Oh, you're closing.
I'm going to close the public... Oh, does somebody...
We opened it. We've got to hear everybody.
Do I have a card here from you, Mr.? Well, for the public forum. You do?
And I want to speak.
Okay.
Let him speak to the
I'm-
issue of continuance.
Right, you can speak to the issue of continuance. I don't have a card in front of me, though.
Well, it's up there. But I repeat, I wish to speak.
Yes, I said, please go ahead. Yeah. I just don't have your card on that item for the continuance. I know that.
Speaking in the public interest. Now, I've been in Los Gatos for 8 years, and I clearly remember some 4 or 5 years ago when the tree permits, the tree fights, the tree fines, underline, accentuate, Mr. Korb, tree fines were issued by the town of Los Gatos. Okay, I'm not going to bet my life on it, but I almost, okay? So you folks need to understand Mr. Wiseman's position on fines is, in my opinion, 100% valid, based on my memory of the process in Los Gatos, okay? Also, I want to bring to your attention my concerns. I read here that there was an illegal grading adjudicated by the DRC and found no problem or dismissed it. Well, as we know from last week's study session, the DRC is nothing but a gang of employees that answer to their boss, the planning director. And the planning director makes the decision whether or not to be approved. If he agendizes it before the DRC, it's an automatic approval. You heard that. In the last 5 years, there's been some 289 homes approved through the DRC and not one denied. Not one in 5 years in 250 homes. So again, I tell you, to have it itemized, agendized before the DRC is one man's approval. The planning director, and everything he does is in secret. It's an abomination. So, Mr. Weissman, stick to your guns and sock it to them.
Okay, thank you very much. Mr. Davis, would you please fill out a card, too, for speaking again? I mean, just sometime tonight. Just grab a card and sit down and fill that. You don't have to come back up to the podium. Thank you.
Madam Chair?
Okay.
Just as a closing note, I assume that you're going to seek a motion to continue, but just as a closing note on some of the questions raised, difference between the tree protection ordinance and the grading ordinance. I've already given you information concerning the imposition of penalties for violations of the grading ordinance. First, in this situation, it's my understanding from staff that the tree mitigation that was imposed as part of the penalty was part of the penalty for the grading violation. So it falls back into the same category as other penalties for grading violations. Secondly, under the tree protection ordinance, there are essentially two sections that deal with consequences. One section gives the director of community development the authority to impose as a condition of approval mitigation measures for any trees that are damaged or lost as the result of any actions on the part of a property owner, including actions in development. However, penalties can only be, and I'm talking monetary penalties, can only be imposed, again, through a civil action initiated by the town and determined by a court. So, again, my opinion would be the same with regard to monetary penalties imposed for tree violations, but mitigation for tree violations in the form of replacement can be imposed by the director as a condition of approval, can be subject to appeal. But I don't believe that's what happened in this situation, and we can address that more fully when the hearing is before you.
Okay. I'm going to close the public hearing now. Thank you. And Commissioners, I'm going to turn this over to you, and with my recommendation that we do continue this only because it just seems like we're not working with everybody that's ready to present their side. And I have a question of Commissioner Kane.
I'm prepared to make a motion, subject to other commissioners want to comment. Let Tom O'Donnell comment.
Would you like to, you're not ready yet, Commissioner Kane?
He's ready.
Okay.
I just want to say
Commissioner
this,
O'Donnell.
that we might be prepared to go on one of these, but I have to say the record is anything but clear. We found out from council this evening that notwithstanding what the staff did, they shouldn't have done it. We also heard from one of the speakers that the differentiation between the penalty and the trees has not been clearly made, and after listening to this discussion, I agree with that. I would like to think that if we would continue this until March, we would have a complete package in front of us, and we would find out, for example, what, if anything, we can do. We've heard we cannot impose a monetary penalty, although the town can, by the ways illustrated. But then in certain circumstances, we could sustain a requirement, I guess, to impose mitigation for what has been done, namely put in more trees or whatever. But the record isn't even clear, at least it isn't to me, whether that's been recommended by the town, and if not, whether the appeal extends to that so that we might have jurisdiction, notwithstanding that the town has thus far not recommended that, to make our own recommendation for that. I would certainly like to be able to do that if the facts were sufficient to justify that. But on the basis of what we have before us, it is less than a clear record. And for that purpose and that purpose alone, I think everybody would be served. I think as a courtesy to council, but I have to say, if that were the only issue, I'm not sure I'd be disposed to continue it. But in light of the fact, I don't think we're doing anybody a favor by not being clear about what we can do and what we are doing. I really believe it's to both appellants' advantage to have this thing much clearer, and it would be wonderful if the staff could make it clearer for us, so when it's set in March, we know what we can do and what we can't do, and what we should receive evidence on and what we shouldn't receive evidence on. So I'm sure I'm going to support Commissioner Kane's motion when he makes it.
Commissioner Kane.
I make a motion we continue both appeals to a date certain, that date certain to be as soon as possible.
That would be March. Do you want to add March 12th in there or not? March 12th. And you have a second. So we have a motion to approve a continuance to March 12th with a second. All in favor? Aye. And opposed? None. So motion carries 7-0. Okay, thank you, Commissioners, for your time on that. I appreciate it. And thank you, members of the audience, for your time on that, too. All right. As is your right, that you will have a chance to speak tonight, both before any public hearings and during public hearings. If you are an applicant, you'll have 5 minutes to present, and then 3 minutes for any rebuttal clarifications afterwards. And as an audience member who wishes to speak, you can have two opportunities. One is before I open the on any item, that is not on our agenda, and that'll be in the public forum. Otherwise, you have another chance to speak for 3 minutes on any item as well. And please remember to fill out a speaker card so the town has record of who did speak tonight. Thank you, and I can see who you are and pronounce your name right. So with that, we have nothing on our consent calendar, but I will open the public forum, and I have a speaker card from Citizen Ray.
Madam Chair,
Yes,
we do have some subcommittee reports.
we do. Citizen Ray, can you? That's right. Why don't you walk over to the podium? We'll be right with you, okay? And thank you, Commissioner Bourgeois. I didn't think we did. I checked with everybody but you. Thank you.
Wow, I'm feeling left out.
Oh, either left out or I'm feeling embarrassed.
I will just
Thank
very
you.
briefly report that there was a joint meeting of the Planning Commission and Community Services Commission last week,
Of course.
at which meeting the mayor attended, and an advisory subcommittee was formed on sustainability issues, and it was determined that there will be 2 planning commissioners seated to that subcommittee, to be determined at our convenience. That's it.
Terrific. Thank you very much. I understand that meeting went very well. So thank you. Okay. And with that, I will open the public forum. And I have one card, Citizen Ray.
Yes, a couple subjects. First one, study session on the DRC last week. Beautiful. And I want to tell the 5 that were here, Mr. Kane, Ms. Talfor, Mr. O'Donnell, Ms. Sayak, and Mr. Bourgeois, what a dynamite session it was. Dynamite. And lo and behold, we had our real estate attorney, Mr. O'Donnell, show up as a public figure, not a private figure. Wow. Hooray for Mr. O'Donnell in returning to the fold, returning to his charge to deal with the public interest and not the private interest. Beautiful job, Mr. O'Donnell. Kane, of course, Mr. Kane always has his book of notes, and he's terrific because he never does anything in the business of the town relative to the personal whim. He sends a message for all of us that are involved in the public domain, how good it is to be right and proper in the process, okay? Last, I got time left. Well, those of us who put kids first on Yes on D didn't do so well at Election Day, okay? We lost pretty badly. But I did check with the office, the Registrar of Voters today, and we picked up about 1,000 more votes than the last time it was reported in the Mercury News. So we have about almost 4,000 votes, yes. It was terrific. We lost, but it was terrific. And we will not rest until those 4,000 votes are heard by the so-called democracy in the town of Los Gatos, okay? We the people speak and nobody's listening. But you think we're going to give up? Hell no! We're going to take a page out of American history. When John Paul Jones retorted to the British captain of the HMS Serapis, when the captain demanded his surrender, John Paul Jones said, "Surrender hell! We've just begun to fight." So that's what it's going to be with the kids, for the kids, the skateboard park, no quit in the 4,000. So stay tuned. Thank you.
Thank you very much. Okay, Commissioners, we're going to go right to item 1, and actually, item 1 is 115 North Santa Cruz Avenue and 112 Wilder Avenue, subdivision application M-07-005, general plan amendment GP-07-01, zone change Z-07-01, variance application V-07-01. Property owner is Santa Cruz Wilder LLC, and applicant is John Lean. This item is continued from January 23rd, and the public hearing was closed on this item, so it will go right to us for discussion. I do have a card on that, and I won't be hearing you tonight, maybe on another item, but anyway, Mr. Suda, I was hoping that you might recap for us the actions on number 1 from the Planning Commission from last time. And with that, one other thing before you start. Commissioner Rice, you were...
I was not here on the 23rd, but
Yes.
I have listened to the tape.
Okay, thank you. You're prepared. Do you have any concerns or... Okay. And anyway, so let me hang on 1 minute. Mr. Suda. So if you or council have any concerns, by the way, please let us as commissioners know about our actions from what we did. And if not, we'll just continue with the second half of this.
Okay, you do want me to
I do want you to recap. Yes.
All right. So, as the Commission will recall, this item was continued from your meeting of January 23rd. At that meeting, the Planning Commission took public testimony, closed the public hearings, and began deliberations. At that meeting, the Planning Commission took action to approve the architectural and site application without the 2 retail buildings in front of the mansion and without the parking spaces on the east side of the alley. The Commission granted the negative declaration and approved modifications to the conditional use permit to reduce the number of seats that are allowed. The Commission at that time continued the remainder of the applications to this meeting. So the applications that remain before you tonight are, 1, a general plan amendment that would apply to the remaining parking spaces on the west side of the alley, and that general plan amendment would be to change the land use designation from medium density residential to central business district. Similar zone change for that same area from R1D to C2, a lot line adjustment to separate the remaining parking area from the remainder of the Wilder parcel, and then 4th, a variance application to eliminate the existing parking lot on the Wilder parcel. So at this point, with the public hearing closed, the Commission may restart its deliberation on the remaining 4 items.
Okay, Commissioners, you heard it. And do we have questions of staff at this point? Commissioner Kane?
Mr. Suda, the question was, how do you eat an elephant? And the answer is 1 bite at a time. What I think we tried to do with this multifaceted case was to break it into 2 pieces. One concerned, we'll call it Santa Cruz, the other concerned Wilder. Now, we may think that we wrapped up Santa Cruz, and tonight we may think we just want to address Wilder. Is there anything inappropriate in the way we've approached this so far? Can we break it into 2 pieces?
Well, yeah, I think you did. I'm not sure what the question is.
I'm looking for not being second-guessed on a technical procedure that we should have taken the whole thing as 1 piece and we couldn't break it into 2. I think you've answered my question. It's okay to break it into 2 pieces.
You broke it into 2. As you'll recall, the council at that meeting, since Mr. Korb wasn't here, suggested and advised that you keep it as 1. Suggested you take the actions as a whole. At that time, you chose not to do that. You were prepared to act on the Santa Cruz applications, and you did so.
Right. So you're getting to the guts of my question. The council that was here said maybe that wasn't a good idea. Now that the town attorney has returned, I'm looking to see if we missed a technicality, we're going to have to go back and do it again, or can we go forward and handle the second piece, which we are calling Wilder?
Well, I'm going to assume that your question is, have you made a procedural error that would result in some kind of reversal of your decision to split the application? And the answer to the question is no. You can split the applications. Staff has expressed in the past, I expressed today, and my replacement at the last meeting expressed at that time, what is a fairly consistent position, that because of the difficulty in scheduling follow-up hearings and some of the confusion that results therefrom, that we like to keep everything bundled together. It is a matter of procedural preference, good term, not a matter of legal necessity.
Thank you, Mr. Clerk. I appreciate that, and I appreciate the question, actually, I think. Commissioner O'Donnell.
If I recall correctly, and I very well may not, one of the reasons we split this was on a matter we'd had, the motel, as a matter of fact. When the council got that matter, there was discussion with the council that we could have done more. Instead of, we essentially were asked for an up or down decision, and we said, fine, you lose. And the council said, no, that's, if I understand them correctly, don't do that. Try to get as much done as you can, so when it comes up to us, it will be more refined. So when we had this before us, I, for one, trying to follow the council's, my understanding of the town council's advice, said, well, let's do more than say no. And therefore, we thought, okay, let's split it. And that's what we did. Now, if I understand this correctly, and this is my question to you, the lot line adjustment relates solely to the parking issues and to the, well, to what extent, one of the questions will be, to what extent does it apply to the parking lot? Because at the end of the day, I think what the applicant was asking us is they want a single-family residential lot where I don't know, 12 spaces are now or whatever. That's the one that opens onto Wilder. They want to take, the lot seems to spill over, and they want a lot split so that the residential is one lot, the balance of the property is another lot. That's the lot split. The zone change, if I understand, this is, I find a little confusing. One of the zone changes allows the residential building to be built, but that I think is already zoned for residential. The other conversion simply allows, I think it allows the use that is being asked for. Now, the use that is being asked for on Santa Cruz Avenue is both the restaurant use, which is a CUP use, as I recall, commercial, and I thought there was some office, but none of that has anything to do with here. So when I look at the list, lot line adjustment, I understand that. A general plan amendment from medium-density residential to central business for a portion of the parking lot parcel. And I guess I'm confused by that. What portion of the parking lot parcel? Is that the west side of the parking lot?
What staff refers to as the parking lot parcel is the Wilder parcel. That's the
west side
of the alley.
Okay, and all right, so that's that. Then the zone changed from R1D LHP to C2 LHP for a portion of the parking lot parcel. And is that the same portion?
Yes.
Okay, so that would be consistent with the other zoning on the easterly portion of the property. Is that correct?
That's right. If it would be helpful, I could go up to this exhibit and walk you through it.
That would be great.
In fact, can we put it up on the overhead at all? Is that possible?
Mr. Parsons, you have the, okay.
All right. Do we?
This drawing that's up here on the wall, let me just orient you to the drawing. You have North Santa Cruz to the right side of the drawing. You have Wilder to the left side of the drawing. And this is the existing alleyway right here.
Oh, we found one. Okay, terrific. Thank you. This will make it much easier. Okay, excuse us for a few minutes while we get this on the overhead. we will be putting the parking lot configuration, proposed one, from sheet 1A of our packet, Exhibit 20, from Exhibit 20. Thank you, Mr. Suda.
Okay. Let me first orient you to the drawing. On the right side of the drawing is North Santa Cruz. The left side of the drawing is Wilder. The alley is this section in the middle of the drawing. The general plan amendment and the zone change apply to this area here where they are proposing to retain parking. This parking would be for the benefit of the Santa Cruz parcel. The lot line adjustment will move a lot line from here to this dashed line here. What that does is establishes a separate parcel for this piece of land. This is the piece of land on which the applicant would like to build a single-family home. So it separates the two parcels. This becomes part of this parcel. The general plan and zone change for the remaining parking area would change from residential to commercial, which is consistent with the zoning designation for the Santa Cruz parcel.
Okay, do we have questions so far? Anybody? Okay. So, Randy, the guest parking that I see here, marked by the two visible triangles?
There's two triangles inside the gray box, which is the garage.
Right, okay.
Thank you very much.
Let's go on with it.
All right. Does that clarify? All right, who else would like to, yes, Commissioner Bourgeois?
I'll just make a quick comment. I appreciate the summary with the visual, kind of crystallizes everything. When we heard this at General Plan Committee, the subdivision application, the general plan amendment, and the zone change, they all make perfect logical sense as to what they're trying to achieve here. The one thing that is a little bit of a concern to me, based on evidence I heard at the last meeting, is the variance. So to take parking spaces out of the parking assessment district requires a variance. And so that was the question. Is there going to be some harm in removing 30-something parking spaces from the parking assessment district? That's the only thing that I heard that raises any red flags on these applications. And what staff is telling us in their report is that they still meet their parking assessment with the removal of those spaces. Is that correct?
Let me provide a little background on that, on this aspect of the application. When the parking assessment district was established, the calculations first included the number of spaces, private parking spaces, that were being used for businesses downtown. So they first looked at how many private parking spaces exist. Then they allowed property owners in the parking assessment district to purchase additional parking credits. The town code states that you cannot remove or eliminate private parking, that was factored into the parking assessment district calculations. So what the applicant is proposing to do here is to remove parking spaces on that Wilder parcel, private parking spaces, and consolidate the remaining parking on that alley piece. The variance is, let me back up. So with the approval of the CUP to reduce the number of seats in the restaurant, that reduces the parking demand. With this proposal on the remaining number of parking spaces, it meets the parking calculations. The variance is to that section of the town code that states you may not remove spaces that were included in the parking assessment district calculations. When that section of the town code was written, it was not contemplated that a property owner would reduce the intensity of development or reduce the parking demand on a property. Therefore, they didn't put into place a process to make that occur. So in this case, the only process that is available is the variance process.
Commissioner Bourgeois, did that answer your question? Okay. Commissioner O'Donnell?
I want to make sure I understand. The reduction of hypothetical seating spaces in that restaurant is hypothetical, isn't it? I mean, I've been in that restaurant a number of times, and I don't suppose they're suggesting that any of those tables are going to be removed. If I recall correctly, they have a right to have some serving spaces elsewhere, which they're not using. So when you come there and that parking lot is full, as I have come, and it has been full, we're now saying, well, theoretically, you really don't need that parking space, even though actually you do. Theoretically, we're giving up seating area, even though we never used it. So if we put those two hypotheticals together and ignore reality, we really don't need the parking. I mean, that's the way I understand this analysis. Because we have to make a finding that unusual or special circumstances that encumber or place any undue hardships on a property. And the whole basis of this is they've had a reduction in imaginary seating, which should influence how much parking they need. Do you know whether, in fact, any seating they've ever used is being reduced?
Well, let's remember the CUP was written for the Chart House restaurant. So legally, the conditional use permit allows for some 198 seats. When Travis took over the space, they, to date, have chosen not to use the 198, and they're using something in the order of 135. I think 135 was their request. So the CUP modification was to reduce it from 198 to 135. Until that CUP modification is effectuated, legally they have the right to have 198 seats in that space. So the parking calculation is based on the approved CUP that's in place.
Well, I'm just kind of wondering to what extent one can find special circumstances. The additional, well, one can find special circumstances when you observe that when 135 spaces for diners fills that parking lot on a number of occasions. To what extent must one take into consideration that in determining whether there are special circumstances which would allow the reduction?
Well, certainly your observations are part of the evidence that you can present to the rest of your commissioners as you're discussing this. You've got the on-site spaces that are remaining, and the applicant's property owner owns 44 credits in the parking assessment district. They're not on-site. They paid for the right to 44 spaces in the parking assessment district. The calculation is being run consistent with how the town runs its parking calculations for any parcel within the parking assessment district. The variance is not to allow them to deviate from the parking calculation or the parking requirements. The variance is to allow them to remove those private spaces that were previously included in the calculations that are no longer needed for them to meet the parking requirements. So, similar situation to Almendra, where the commission granted a variance in 2006 or 2007, 1 or 2 years ago. Similar situation where the commission approved a CUP to convert a parcel that was used for an office use, converted to a single-family residential use. They removed the private parking lot in the back of the structure. Variance was granted in that case, and the commission was able to determine that that was an extraordinary circumstance, a reduction in the demand for parking where no process or provision in the town code allows for that. And then it was an extraordinary circumstance for a property owner to reduce their parking intensity.
A question?
Commissioner Riccici.
Just to clear up my confusion on it, are they still paying for 44 credits? Okay, so they've reduced their seating to 135, but still paying for 44 credits. So the overall amount that they require to have are less now than what they had before, correct?
That's correct.
Okay. Thank you.
Commissioner Kane.
Mr. Suda, the staff report indicates that they need 57 and that they have 57. real and PAD. Does that mean, by those numbers, that we are precluding at this point any outside dining?
No, it's actually 51 and 53, but they require 51 spaces. They're providing through on-site parking, and their parking credits 53 spaces, so they meet the parking requirements. It allows the maximum in the CUP, the 135 seats, counts seats inside and out.
So if there's 135 inside and they wanted to have some outside, they'd have to move 4 tables to the patio?
Right. What the commission did is establish a maximum number of seats. They allowed the applicant the flexibility to place the seats and allocate the seats how they wish.
My second question, in marking the old parking lot, the signs dedicated those spots to the restaurant. With the new spots that will be put up on the west side of the alley, will those spots be dedicated or will they be open to the public?
There are still private parking spaces.
Thank you.
Okay, Commissioner O'Donnell. Yes.
At our last meeting, Mr. Arze stated something as a fact, which I don't have personal knowledge of, but nobody questioned him. I'd like to find out. Mr. Arze said, you know, it makes perfect sense to do this, but that when we originally had talked about it, the concept was the town was going to build 2 more parking lots. And that was the original discussion, and of course the town has not built the 2 more parking lots. So again, we get back to the hypothetical versus the reality. I mean, I have no doubt that if we remove the parking from that parking space, from that lot, it is going to make it more difficult to park when you go to that restaurant. I mean, I say that because I've gone to the restaurant, and I've parked in that parking a number of times. So I don't, you know, I'm kind of on horns of a dilemma because I don't want to be punitive towards the use here. But it just seems impractical to me to say if the town was talking about putting in 2 lots, didn't put in 2 lots, is going to give a credit for not using something they're not using anyway and haven't used. The memory of man runneth not. I don't know when they used that. We get pretty theoretical except when we try to park our car. Yeah. So staff seems to be very comfortable with this as a variance, and I think, if I read you correctly, you're very comfortable with it because it all cancels out.
Right.
Yeah, and let me just clarify that when the parking assessment district calculations were run, they didn't assume the construction of additional public parking lots or parking structures. They were based on the parking that you see out there today. There has been talk in the past of the town building more parking facilities in the future. At this point, there are no plans to do so. But the parking assessment district calculations were not premised upon additional parking structures being built.
And if I may, Madam Chair, just add a little additional history. The discussion regarding the construction of additional parking structures, as you probably recall, is relatively recent history. It doesn't date back to as Mr. Suda said, the establishment of the assessment district for parking. It occurred towards the end of the last century, let's say. Ultimately, the council decided not to, as you well know, not to construct additional parking structures, but it did implement a new parking control plan. That parking control plan did provide additional parking elsewhere in the town, and it did also improve the efficiency of existing parking on the streets in other areas, like, for example, on University Avenue, which had previously been subject to a 24/7 permit parking restriction. So there was additional parking established within the district, but it was established not through the construction of structures, but rather through a more efficient use of the space that was available in the area. And the other point that I wanted to make is that the parking assessment district covers a large area. It doesn't assume that there's going to be parking spaces necessarily always adjacent to any given business. It assumes that there's going to be parking spaces within the assessment district. But not everybody gets, a guarantee that they can walk 5 feet to wherever it is that they're trying to get to.
Commissioner O'Donnell, you did bring up a good point. I do remember Mr. Arzi also speaking of it. He was very involved with the general plan and the goals at that time, which included the parking. And I believe he said that lot actually was calculated into the parking district as it was created. And I worry now that when that goes away, will we tip any balance? So I'm hanging on that a lot right now. So Commissioner Kane, Commissioner Matici, and then Commissioner Rice.
Is it our intent to now be moving toward a motion?
It's our intent to be moving toward several motions.
I'm wondering if there's a way to address a question to the applicant or the contact person as listed in the staff report.
What would the reason be?
How would that be open?
Yeah, I would have
I want
to
to reopen
reopen
for one question.
for one question.
Let me express what my question is first, and then you decide what you want to do.
Okay, let's hear it.
If you look at map 1A, which is on the board,
Which is on the overhead.
and you look at the alley runs through it. To the west side, you see the old and the new parking places where they used to be and where they shall be. If you extended that down into the so-called guest parking, using my ruler at home, I created 4 more spots plus the accessible spot, known to me as the handicap spot. The handicap spot and 2 other parking spots were eliminated from the grounds of the mansion, and the staff report said if we now put that accessible spot into the proposed parking, it would eliminate one of the spots. Well, I extended it down to the so-called guest parking, and the measurements I took allowed 4 more spots with a runover, a little bit extra, that one of them could be accessible. I would find this whole thing more palatable if we carved out those 4 more spots at the expense of the so-called guest parking and access to the garage from the alley. I'm just wondering if that has any merit to it at all from my commissioners or from anyone else.
Wait a minute, I had comment also from Commissioner
I think these are
Matici.
follow-ups to that.
Okay, would you like that follow-ups?
Go
Okay,
ahead.
Commissioner Bourgeois had his hand up first, followed by Commissioner Sayoc and O'Donnell.
I would not be supportive of that. I think that's the primary access to the homes on that street, and then they have to push the garage. There's no room to build a house. Then we're talking about access to a garage from Wilder, which would be incompatible with the rest of the neighborhood. I think that would just create a mess for that parcel from the residential side. I think all the houses there have access through that alley, and by eliminating that, I don't know what they could build there that would be acceptable from a neighborhood compatibility
It would be small.
issue. So.
Okay.
It would be small. I would tend to agree with that, but any follow-up here, Commissioner
That's my same
Sayoc?
comment, so.
Okay. Okay, so does that answer your question, Commissioner
I was just
Kane?
going to point,
Oh,
and you'd have to change the lot split, too,
Yeah,
which
right.
is not before us. I mean, that would have to be re-engineered and the whole thing. But I think the substantive comment is more important than the technical comment about, we don't have that before us, so.
right. So, Commissioner Matici? Last, okay, you'll find it, I'm sure you will. Commissioner Rice, you had comment, questions?
Well, kind of to follow up to what Commissioner O'Donnell was saying, and to give kind of thoughts of where I am at the moment in heading towards motions or whatever, the first 3 items of the subdivision, the general plan, and the zone change seem to be kind of no-brainers to me. And struggling with the variance application, the concern I would have is to turn it down would be almost unfairly penal to one particular applicant. You meet all the rules, but we don't like losing parking, so therefore, the fact that you meet all the rules really doesn't matter. So I'm kind of headed towards where I think that there's not much more blood to get from the stone. So I just wanted to put that out there.
Okay.
I'm going to make a comment, because I'm not sure I understand what the issue is.
Commissioner Matici, okay.
The fact is, they've dropped the seating in the CUP from one number to another, which automatically reduced the number of parking spaces that they needed. So the town hasn't lost any parking spaces. effectively, before with the CUP as great as it was, resulted in them needing more parking spaces. Once they reduced it, that need goes away, right? And they're coming out two ahead, from what I understand, 53 to 51. So what are we concerned about here? I'm not sure what we are concerned about.
I think we're going to hear about it in just a minute from Commissioner O'Donnell, but did Commissioner Sayoc, you had your hand up for comment, and then you took it down, you're okay at this point? All right, Commissioner O'Donnell.
I don't feel emotionally committed to this, but intellectually, I have to say, it's all well and good to talk about a reduction in imaginary seats as somehow affecting actual parking. Just a minute, let me finish. And as far as penal versus variance, you've got it backwards. To find a variance, you must make affirmative findings. That's unrelated to penal. We're being asked to make affirmative findings, nothing to do with punishing somebody. We're asked to make a variance, which is a favor. So we're being asked for a favor. That's not technically correct, but we're being asked to make the findings. Now, there is a reduction in the maximum number of seats which could be there and haven't been there for a number of years, and I'm simply telling you that that parking lot is full all the times I've been there. So you can give it away, and you can say it still works out on paper, but for the people who no longer park there, they can walk to University, or maybe they can walk down to where the skate park was going to be, because that was another issue. But I'm just telling you, as a practical matter, and as a resident of Los Gatos, I'm very uncomfortable with giving up something where I have to make a finding that this particular property would have an undue hardship if it had to keep what it's already agreed to do, and that there are special circumstances. Now, the way to solve this problem, and if I understand the town attorney, the town could adopt an ordinance that says, hey, here's how we came up with all this stuff, and here's how we back it out. They didn't do that. So we're kind of making it up as we go along. But you have to make a variance finding that there are unusual or special circumstances that encumber or place undue hardships on a property. And I don't think the person who says, I want to reduce my parking, therefore and consequentially has an undue hardship. Nobody asked him to do that. He did it. Great. Appreciate it. It doesn't place an undue hardship on the property. If it's a quid pro quo, then everybody can come in and trade with us. That's wonderful, but it's got nothing to do with variances. So that having been said, I still feel badly for the applicant, and I'm not going to step in front of the train, but that's the way I look at the logic.
I would add to that this is not an existing hardship as it is, but to eliminate the parking lot could create an existing hardship on the parking district, is how I look at it. And so that would be my comment.
I agree with Commissioner O'Donnell that the issue is not made by the fine. What I'm saying is mathematically, the seats have been, the need for traffic has been eliminated by that restaurant by reducing the number in the CUP.
But
The need for seats in the area have been reduced, regardless.
And have we discovered the use that will be needed for the offices?
No, the full amount of parking they need has been reduced.
Okay.
The office is in the calculation.
Okay, the office is in the calculations, all right. Thank you.
May I ask the staff a question?
Commissioner Michichi, since you have the floor, yes, followed by Commissioner Kane.
Excuse me, Mr. Suru, you stated before that the policy didn't account for this specific type of thing. As a result, there's no way in the process that we can do it. How have they done it in the past then? I mean, how do we take an action here to allow this to happen if we can't make the findings, as Mr. O'Donnell has stated?
The commission has made the findings and has granted a variance on Almendra. Again, I talked about this earlier for
I realize that, yeah.
Existing office use converted to a single-family residential use. There is a private parking lot to the rear of the office building. That was eliminated when the CUP was approved.
And they use these findings to do so.
Right.
Commissioner Kane.
First, I want to make it clear, I like and support the project. The no-brainer aspect that Commissioner pointed to on items 1, 2, and 3, I think. Where I'm getting hung up is the other commissioner mentioned variance, and that's not to be taken lightly, said Commissioner Bourgeois, and I'm not taking that lightly. In the staff report, provisions of Section 65906, a variance is appropriate for special circumstances or that would place any undue hardships on a property. And that's what we've been talking about. And I don't see the undue hardship. I like the project. However, a man bought a parking lot. He didn't buy a piece of land on which he could for certain build a house. So he still has a property that he bought that is still used for what it was. I don't see the undue hardship. I want to find a way to make this work, but I don't want to wink at the aspect of variance. And I don't agree that Almendra is all that applicable, and beyond that, I want to take things on a case-by-case basis and not start adding up precedent value to our decisions. My memory's not that good. But I'd like to find a way to make this work, but I don't want to wink at the variance aspect.
Okay, do I have any other comments about this? I would like to get us going toward making a motion very soon here. To the members of the audience, excuse me, I will address that. The public hearing was closed.
Continued, it says.
Right, but we had closed the public hearing.
Well, I go to the district attorney.
Do you need a note?
Commissioner, Mr. Counsel, Mr. Corr, would you like to comment?
As in the past, the public hearing was closed. The item was continued for decision by the commission on the remaining portions of the application. Under the Brown Act, the full public hearing has been held, and it is not necessary to take additional public comment. You can choose to do so, but you're not required to do so.
Okay. And at this time, I will not, because I had made that point clear at the beginning of this. Right now, you're disrupting my meeting, so thank you. Okay, Commissioners, getting back to what our discussion is, and we need to arrive at some conclusions tonight by the way of motions. So, shall we, is anyone ready? Do you have any more questions? Do we want to take a consensus vote first? Would that help us at all? All right, do I see a hand up with the commotion? This is, yes, Commissioner O'Donnell.
Let me just say one thing, because I'm not trying to confuse anything. I'm troubled by the variance aspect, but to what Commissioner Kane has asked, and I've tried to say, if my fellow commissioners believe they can make those findings, I think they could be defensible. So I'm not suggesting one couldn't make the findings. I personally would have great difficulty making those findings, and therefore I don't think I could. But I'm not suggesting that, sort of as a matter of law, nobody can make those findings. So if anybody has understood me to be that strong in this, I don't mean to be. I told you the practical realities, and therefore that's why I couldn't find the findings for a variance.
I would have to agree with Commissioner O'Donnell. I cannot either, and I do think the Almendra, although it's an example, isn't exactly apples to apples here at all, because where Almendra went right back to residential, as it was zoned in a residential area anyway, this still leaves commercial need for parking. So that's what we're left with, and I told you what I was hung up on. So I will look for a motion of something. Commissioner Matici?
Yes, I'm going to make a motion.
Okay.
I'm going to find a way to do it. I make a motion to approve the subdivision application MO 7005, the general plan amendment GPO 701, zone change ZO 7001, and the variance application VO 701. I find that all general plan amendments must be found and are consistent with the general plan, that the zone change is consistent with the general plan. I find that by granting a variance, as we did on Almendra, I'm using that as precedence to do it, because I believe that it is not bringing a hardship to the community. Okay, I believe the events, the changings that the applicant is doing in this were predicated on the fact that he was giving up that property to a residential in the Wilder, and as a result, I'm seeing in favor of that. I don't see it, I'm not constituting a special privilege to him at all, and I see this, it's consistent with limitation of the prior. It's required by section 21.9 of the Design Code for granting conditional use permit. Is that done? What else do I need?
Also, Commissioner, Mr. Suda, we also, at the last time, forgot to, I was going to ask you about this. We can, the mitigated negative declaration monitoring plan. Now, we can do that as a separate motion, is that correct?
You can do that as a separate motion, you could do it as part of the same motion.
Okay, so you
What are
didn't
we
include...
requesting here? I'm sorry. I didn't hear.
Yes, we forgot last time to include in our motion the mitigation monitoring plan.
Okay, I'll include it in this motion.
Okay, all right, thank you.
Do I have a
So I
second?
have a motion on the floor. Is there a second?
I'll second.
Okay, I have a motion from Commissioner Machici to approve the various applications, and a second from Commissioner Rice. Yes, Mr. Suda.
Before the commission takes their vote, I want to just clarify for the record that the actions that are as part of the motion are to recommend approval of the general plan amendment, recommend approval of the zone change, to approve the lot line adjustment, to approve the variance, and to adopt the mitigation monitoring plan.
That's correct. That's correct,
Okay.
as stated.
And, yes, now's the time for discussion and questions. Commissioner O'Donnell.
I'll ask the maker of the motion and perhaps also staff, do you think there's any advantage in breaking down your motion so we could take them one at a time? The only one I've heard any opposition to so far is the variance, and I have no idea how the vote's going to go on that. But we all seem to agree on the first three. I'm not sure whether it helps it or not, but it might help the council, assuming this is appealed and assuming for the moment the variance were not approved. And so I guess I'm, one, suggesting to the maker of the motion perhaps we do that, but I'm also asking town attorney, I guess, is whether the town attorney sees any problem with that or any advantage to it.
It's all the same, huh?
I see no problem with it. I assume what you're asking is, can the motion be split and the variance application be dealt with separately? You can do that if you desire, or you can, within the context of this motion, discuss any of the items that are controversial.
I would have suggested that we do them separately, just because, for this very reason, that we have issues here with one of them, it seems like.
You know, it appears to me, if I felt there was any, I think we're requesting, in the event that there were an appeal, it would be better if we separated it. Is that what I'm hearing?
Yes.
I have no problem separating it. I mean, if that would, so I'm not going to repeat them, I've said them, so I'll just separate them, so we can take action on the first three that I stated, and the addition, and then we can talk about the variance one special. So you want to call the first one?
Mr. Suda, did you understand that?
We've grouped four
them, but
together.
now we're going to separate them
Variance
out.
out.
But they'll be the same ones that you
Did the seconder agree?
needed. Commissioner Machici, just a minute. Commissioner Rice, would you agree on that?
Well, if it moves the process along, I will, but I'm just going to,
It will, Steve.
all right, I'll agree.
Wasn't there an additional one?
Was the
Mitigation monitoring plan.
Yeah, right.
3 plus 1.
Okay. And Mr. Suda actually recited all of them beautifully.
Yeah.
Good memory.
Okay.
Thank you.
So we're going to make a call on the first four?
Yes. I have a motion for the subdivision application. All in favor?
No.
Oh, wait.
No.
I'm sorry.
very patient.
I'm sorry. Discussion.
I've been unusually patient.
Okay.
Can I get in there?
Yes, discussion.
I'm not going to support the motion. I'm not going to support anything that has precedent value, Phil. I can't do it. I know you...
We're not talking about that one right now.
Which one is this?
She made the call on the first four. We're
Going
talk about the
to, we've
variance.
separated them
I'm
out.
patient and excited. I'm
Be
waiting my
patient.
turn.
Be patient.
I'll third the motion.
Okay. All right. Commissioner Kane, we have separated out the motions, and everybody agree, got it? All right. All right, and I don't think it matters what order we take them in, but let's go to the subdivision application. Okay?
Well, no, we're doing the group of four and then.
Oh, I see what you wanted to do. All right, so someone get on board here. All right. So the group of four would be the subdivision, the general plan, is this right? The
Zone change,
and the
and the one we left out last
mitigation.
time, right.
Yes, no,
Right.
yeah, thank
Okay.
you. Okay, so all in favor, say aye.
Aye.
And opposed? None. Okay, motion of those four
We don't need, I don't need
passes.
the second one.
7-0. All right, we have, our next motion is for the variance.
Right, so
And
comments on
I
that,
have a comment
Mr. Kane.
on that from Commissioner Kane. Thank you.
I don't think it's a good idea to talk about precedent value in a motion. We often pride ourselves and are guided by having case-by-case objectivity. I really don't want to get into the contract organization, a history of what we've done, implying that would force us to do different things in the future. We have words before us. We don't need precedent value. And we don't need Almendra, because I don't think it applies anyway. That's a whole nother argument. So, Commissioner Machici, I can't support it as stated. I told you earlier, I try to find a way to support it and not wink at the variance, but with any sort of reference to precedent value, I can't do it.
Okay, Commissioner Bourgeois, did you have your hand up?
Yeah, I think I am going to support the motion, and I think the special circumstances that we can make to find for a variance is the fact that this scenario was not accounted for in the parking assessment district. That, to me, is a special circumstance that will allow us to make that finding for the variance. This was never pictured, that they were going to reduce their use and therefore be able to reduce their parking. So if we're caught in some sort of loophole here, that to me is a special circumstance and allows me to make that finding. So I'm going to support the motion.
Commissioner Rice?
In deference to Vice Chair Kane, for the purposes of my second and deliberations on this, I do not look at Almendra for precedent value. I think this stands on its own and is valid in and of itself.
Commissioner Sayoc?
I will also be supporting the motion, and one other thing I'd like to put in there is, although the applicant, as one of our commissioners said, did buy a parking lot, one of the reasons that I am supporting it is currently zoned in our general plan and our zoning as residential. And so, to me, that's another circumstance that would enable me to vote for this.
Commissioner O'Donnell, I think we've heard from you. Commissioner Kane, we've heard from you, and you've heard from me as well. And I will not be supporting the motion due to what I had said before.
I'm more than willing to take
Excuse me,
out the
Commissioner
precedent.
Machici, yes?
I'm more than willing to take the precedent statement out of my motion and replace it by the inputs that Commissioner Bourgeois and Mayor have made, in that there are special circumstances that allow me to make those findings.
And the special circumstances were, John, would you repeat that, please?
The fact that we have a process in place that applies specifically to this property that was never envisioned in the parking assessment district process, a reduction in use and therefore a reduction in property, is a special circumstance, and therefore can make that finding for variance. And if I, just echoing Commissioner Sayoc, she also stated that it is zoned in the general plan as residential.
Right. Ideally, I could support it if,
Madam Chair, just...
yes.
Absolutely, I agree with that. Thank you.
Okay, I just want to make sure it's clear then that what just occurred is that the motion was amended and the seconder accepted the amendment to remove any reference to Almendra as precedent, but to state the special circumstances as articulated by Commissioner Bourgeois.
Exactly. Thank you. And Commissioner Sayoc as well. Okay. And with that, I'm going to call the vote. All in favor?
Aye.
And opposed? Nay. Was that a nay from you? You were an aye? Okay. So that would be 5 in favor and 2 against, and that was Commissioner O'Donnell and Commissioner Talasfor.
Okay, some procedural follow-up regarding appeal rights and so on. The applications for both the general plan amendment and the zone change are, or I should say the actions concerning those two applications are recommendations to the town council. They're recommendations of approval. Therefore, they will be scheduled for hearing before the town council by staff. It will not be necessary to request a hearing. The applications regarding the subdivision and the variance are both appealable to the town council. Anyone dissatisfied with those decisions may appeal those decisions. The appeal must be filed within 10 days. It must be filed in the clerk's department upstairs. There is a fee for filing an appeal.
Thank you very much. And with that, Commissioners, I'm going to take a 5-minute break. are on to item number 2, and there's a desk item. Commissioners, did you all have a chance to look at that? Thank you. This is application, pardon me? Oh, okay. This is application M-7-144S-07-194 at 16683 Kennedy Road. Applicant is Thomas Roulette, property owner is Thomas and Nancy Roulette, and it is a requesting approval to demolish an existing single-family residence and to subdivide a .62 acre property into 2 lots on property pre-zoned R18. APN number 532-08-057. And this is before us, I believe. It's an important issue as far as it's an area where lots are starting to increase in size as they transition from flatlands to the hillside areas. Suzanne Davis, a staff planner, will give us an introduction. Thank you.
The proposed project is located at 16683 Kennedy Road. This is on the north side of the road, just west of Stony Brook. Adjacent properties are all developed with single-family homes. And as the chair already mentioned, the applicant's proposing to demolish the existing house, garage, and guest house, and to subdivide the property into 2 lots that would be about 11,500 square feet each, and to construct 2 new residences. The 2 proposed lots are fairly large given the R18 zoning, but as already mentioned, the lot patterns are starting to change out in this area. They are all larger than 8,000. Included in your report is a analysis on lot sizes, house sizes, floor area ratios out there, and then we've also prepared an exhibit that we can put up on the overhead projector that shows the actual lots in that surrounding area for you.
Thank you. We will. I would like that.
I think Mr. Parsons is going to do that.
All right. Thank you.
The property is pre-zoned R18, and we have been processing a petition for annexation that was filed by the applicant in parallel with these 2 applications that are being considered this evening. That has just about been completed. It's been through town council and accepted. We've sent everything over to Santa Clara County LAFCO for certification and expect that will come through in the next 2 weeks or so. And at that point, the R1 zoning becomes effective. The applicant will be dedicating 10 feet of frontage along Kennedy as part of the application. The DRC does have authority to take action on a subdivision of 4 or fewer parcels, and as the chair mentioned, we forwarded this to the Planning Commission because of it being in this transition area and because the lot patterns are starting to change. The lots are getting larger as we head towards the hillside area, which starts right around South Kennedy Road. The proposed subdivision does comply with the minimum zoning requirements, including lot frontage, depth, and size, and it is consistent with the allowable density established by the general plan. The applicant has contacted many of the neighbors in the area. We have 9 letters of support that were received, 7 were attached to the staff report, and the desk item includes 2 additional letters that came in a little bit late. The applicant has submitted very detailed architectural plans to demonstrate the buildability of the 2 parcels that are being proposed. This is more than we typically see, but they wanted to give you a good feel for what they were proposing to do and for the neighbors as well. The project architect is here if you have any questions, but we will be reviewing those plans at a later date. If the subdivision is approved, those will require individual architecture and site applications. So we will do further. We did do an arborist report. That was just sort of looking at the property in general. We will do another analysis when we have the house plans come in under official applications on the trees out there. So, in order to approve the demolition of the existing residence, there are 4 findings, and those are included in your attachment 2 to the report. The State Subdivision Map Act is done a little differently. Rather than making findings for approval, it includes 7 criteria, and if you can make any of those findings, it's actually grounds to deny the subdivision. That concludes the report, and if you have any questions, we're happy to answer.
Would you just repeat what you just said?
The MAP Act has 7 criteria that are specified in that finding sheet, but that's actually, those items are things that if you can find any of them, then you deny the subdivision. So you're not making those findings to support it. If you can make any of them, you would deny the subdivision.
All right. Thank you very much. And with that, I will, wait, do we have any, I'll entertain any questions for staff at this time. Commissioner Sayoc.
Thanks for the presentation, Ms. Davis. Because there is a known, because asbestos is known, in terms of demolition, are there special circumstances or conditions that we must look at during the demolition phase?
Yes, the applicant will apply for a permit from the Bay Area Air Quality Management District, and they have special procedures for disposing of materials that include asbestos that the contractor would have to follow.
And so those are reflected in the conditions that we have?
It's not in the conditions. That's something that the building department does with all, we do it with all demolitions. We require them to go through that agency and to get clearance from them. And then anytime we have asbestos, that's an automatic requirement.
Thank you.
Commissioner Bourgeois?
Thank you for your staff report. I have a question about the process for future A&S, because I know we've had this conversation up here many times about demolitions and replacement with similar size. And on one side of the argument is, well, if it's compatible with the neighborhood, that overrides similar size. And since we don't technically have an A&S application in front of us, where do we go with that? I have concerns about what I see on the plans, the preliminary plans. They are fairly detailed, and so my assumption is going to be that when they submit A&S applications, that's what we see is what we're going to get, at least pretty close to it. We don't have any review from our architect, so I'm just concerned about how A&S is just going to go through the normal process, and how do we make a decision on the demolition based on those two facts?
I would, because the plans are preliminary, very preliminary, and that's how we're to look at them, correct?
Yes.
Yes, because it's not, A&S is not before us.
Right.
I would say that what we would ask is that the A&S come back to the Planning Commission. It will, I mean, we haven't gotten into the hearing yet, but just from what I've seen, the architecture and site will be extremely important to this whole procedure and hearing, yes.
The reason I asked the question is because we've had cases like this before, and I know this is not a PD. I know in PDs, the preference is to come in with detailed plans, and then that would then get approved at staff level. I just want to know what I'm getting into here with this application, and was that the thought, that they have detailed plans, we make approvals on this level, and then the A&S gets approved at staff level? I just wanted to raise that issue before we start the conversation. So.
It can go either way, and the commission certainly could request that those come back. It would go through a standard architecture and site review. We would do architecture review. We will do an arborist re-review, and any other technical reviews that are required. Story polls will be required, just like any application.
Okay, but still, I think that, John, we would put it in as a condition of approval. That's what I would think. And it comes back to us. I have a question for staff before I forget, and then Commissioner Kane. The 10 feet of that's being dedicated to the town, does that include, just for my knowledge, where the street trees are? Is that what that is? Where's that 10 feet?
It's Fletcher might be able to explain this a little better than me. We require a 30-foot half street. So basically from the center line of the existing road, you go 30 feet back, and that's where the new property line will be established. So yes, some of that landscape area will be technically right away in the future.
So my point is finding out if those trees will remain.
All the trees will remain unless they're specifically approved for removal under an application.
Do we have any other questions? Commissioner Kane.
Ms. Davis, the applicant, the owners, wrote a letter on December 12th and concluded by saying their intentions were to mirror the town's vision for sensibility, attractiveness, energy efficient. Have they said anything to you about a LEED certification?
No, we didn't discuss green building at this point.
Thank you.
Commissioners, if that's all your questions, I will open the public hearing now and invite the applicant up. And when you arrive at the podium, please state your name and address for the records. Thank you.
My name is Tom Roulette, and I live at 16683 Kennedy Road with my wife, Nancy, who's here tonight.
You also should fill out a speaker card.
I'm sorry, I thought as the applicant I didn't need one.
No, you need to. Thank you.
I apologize.
That's all right.
So I come before you tonight to request your consideration and approval to subdivide the lot and build 2 homes on the site. When we moved into the home 15 years ago, it was a fixer-upper then, and the house right now is in a bad state of repair. There are many additions and elevations in the house, and there's, of course, structural damage. There's a separate report that's on file, I believe. There is a cottage. It's a second residence on the property. It's uninhabitable right now. It was also mentioned there's asbestos on the property. Actually, several years ago, my wife had respiratory problems, and it took us several years of investigation to find the presence of asbestos and mold, and we're sure that's contributing to her problems. As we began to speak to architects about a renovation for the house, it became apparent to us that a large single house would be excessive for us and the neighborhood. And a huge yard has been for us expensive to maintain and expensive. So, we considered that maybe 2 houses would be a more sensible solution. It would help share the cost of renewable resources and divide the cost to maintain the property. As we, we also looked at the neighborhood, and we noticed, of course, that our lot right now is the largest lot by far in the entire tract, and would allow a house that would be bigger than any other in the neighborhood. Once again, we felt that 2 smaller houses would make more sense than a single massive house. And in fact, our plans, which are preliminary, call for houses that would be smaller than the zoning limits would allow. So we're already sensitive to the neighborhood. And of course, my wife and I do plan to live in one of the 2 houses. We do plan to use green and low VOC materials. We will have energy-efficient homes and use drought-resistant landscaping. And as was also mentioned, we took our plans to all of our surrounding neighbors, and some of the neighbors have lived there for 30 and 40 years and received unanimous approval and support for our 2 houses.
Thank you very much. Commissioners, do you have any questions of the applicant at this time? I don't think we do. All right, fine, thank you. I will open the public, then to hear from the public, and I have a card, Citizen Ray. If I have any other... I found it for this item, right? Assistant Citizen Ray. And do I have any other cards? Yes. Bring them over to the staff. Mr. Parsons? Thank you.
Yes, I would like to speak from the aspect of community values only, okay? I have a word to say about the spec values, which of course is what this is. The spec proposal, in my opinion, decimates community values, all right? I look at that, those 2 narrow lots that are proposed to be created, 65 feet in width. Can you believe that? We got one nice-sized lot at 130-foot width that's been split right in half, creating 2 long, narrow lots. Totally, in my view, low status, ugly. Since when do you get up in this neck of the woods, when do you have 2 narrow lots which will create, in this case, it's proposed 1 long, narrow home. And to get the perspective on what a long, narrow home looks like in an already existing neighborhood of normal width homes, go down to Placer Oaks and see the 2 long, skinny homes that are being built down there now. It reminds me of my days at Camp Stoneman, okay, at the end of World War II. Oh, I can see those long, narrow barracks, and long, narrow lots create long, narrow, barrack-like homes, okay, typically. And I don't see any community value in, this is an epidemic that is starting here in Los Gatos. Anybody with any kind of an oversized lot is now preparing to split it because of the zoning is so minimal. 8,000 square foot, that's less than a quarter acre. That's itty-bitty. And to inject homes of this nature into an existing neighborhood, it violates the infill policy and everything else that Los Gatos is about, in my opinion. Thank you.
Thank you. So is there any questions? Seeing none, thank you. Okay, I don't have any other speaker cards at this time, so, oh, we do too. Jeff Miller.
Thank you and good evening. My name is Jeff Miller, and I live in Los Gatos here with my wife, and we live on Twin Oaks Drive, which is further up Kennedy, so I drive past this area every day, sometimes several times, and so I'm here to speak on support of the proposed subdivision, and I've included, my letter has been included in the application as well, and so I think I'd like to just reiterate a couple of the points and say that I do think that the lot sizes as proposed fits in actually quite nicely with the progression from smaller lots down towards Los Gatos Boulevard and going up towards the larger lots up on Kennedy and further in the direction that I live in. And so the progression and the growth as it goes forward is consistent, I think, as proposed. As the staff indicated, the lot sizes start to grow as you pass South Kennedy, which I think is just on the far right of this picture, so you don't see those larger lots there. But even looking at the way these lots are here, even the adjacent lot just to the left of the two proposed lots, it seems to me that it fits in very nicely. And I have seen the plans, and even though they're preliminary, I do think that they're consistent with the homes that I see in Los Gatos, and I would expect the applicant would be consistent with his own initial plans and that it would fit in very nicely. In terms of potential concern of how the homes would fit on a long lot, I think the answer is just small size. You can't see the layout here, but I suppose if you look at the other plans that were submitted, you can see that there's a sensitivity to the width of the lot, that's been considered in how they lay out the plans. They haven't proposed to build out to the maximum allowable on these narrow lots. They're staying beneath that maximum allowable. So I think that it resonates, that the considerations for the lot widths, the size, the floor plan, et cetera. So those are the main points I'd like to make, and to, again, indicate my support. I think it's a good idea.
Thank you very much. Do we have any questions, Commissioners? None. Thank you. All right, I don't have any other speaker cards, so I'm going to close the public hearing at this time and turn this over to Commission for... Oh, I am so sorry. Excuse me. My apologies. I'd like to call the applicant up. Before I'm going to reopen the public hearing. Thank you. And call the applicant up for rebuttal.
Thank you.
Or clarification.
For clarification, the accusation's been made that we're somehow going to do the neighborhood a disservice. As I mentioned, we have the complete support of our neighbors, and many of these neighbors have lived there for a very long time. We love the street, and we love our neighborhood. We wouldn't do anything to it to create an eyesore or ugly. In fact, one of the drawings that's in your file that's been left out, if I may, is, again, a preliminary drawing. Sorry, it's crazy. But a preliminary drawing of the two houses. And you can see that I would not call them ugly. And they are not, as I said, going to the full extremities to the zoning limits. They're smaller than they could be. with, again, a sensitivity to the neighbors and the neighborhood, and meeting our own needs. The lots further up the street, you saw the map further up the street, it's a 7,000 square foot lot. We're going to have an 11,000 square foot lot, two of them. So it's our plan, it's our intention to create two homes that are going to be beautiful.
Okay, thank you. Commissioners, do you have any questions? Okay, Commissioner Sayak.
Thank you, Mr. Willett. Actually, I was impressed by the efforts that you did put forward in talking with your neighbors and their letters of support. My question is, though, and it lies with my concern, looking at the minimum width is 60, and 65
Correct.
to me is narrow. And so one of my questions to you is, when you were considering how to cut up your lot, instead of an east-west, did you consider it a north-south so that one would be in front of the other if you're looking at it from Kennedy?
We didn't consider that, and I believe the zoning is that I need a 60-foot frontage, but we didn't consider it in any event because actually this lot just south of us, a 12,000 square foot lot, at one time had a small ranch house on it, and now it has a 4,000 square foot house that's built out to the full extent of the zoning. And as we sat in our small ranch, we lost our sunset. I mean, we used to, the reason I bought the house, we went there, my wife fell in love with it, and they built this house next to us within the limits of the zoning, but we used to watch the sun go down over the hills, and we don't get to see that anymore. And quite honestly, I promised my wife I would get her sunset back, and we have a window on this side just for that. So that's the reason why, quite honestly, we went up 2 stories on one of the houses, and we replaced an old ranch that we have now with a modern new ranch. So you're not losing anything. I know it's a beautiful house from the road. We're not going to take anything away from that neighborhood.
Do you have any other questions, Commissioners? I don't see any. So these are the proposals that you are.
These are our houses.
These are your houses.
What they're going to look like.
It's not on our agenda. It's not what we're looking at tonight. But I just wanted to clarify that. Okay.
Okay.
Thank you. I don't have any questions either. Thank you.
Can you put up the other drawing?
Which drawing do you want up, Commissioner King? The first drawing?
Thank you.
The map. Did you have a question as well? No. Okay, with that, I will close the public hearing. I don't have any more speaker cards. And we've heard from the applicant, and now I'd like to hear from the commissioners. Commissioner O'Donnell.
It raises all kinds of interesting issues. I mean, part of me is disposed to saying having smaller lots has a good purpose because we're trying to make housing more affordable for people. I realize that maybe marginally so, but nevertheless, some higher density does help. We've had that issue. On the other hand, you look at the lot immediately to the right, I think that's, my eyes are not so good, but I think it's 21,000 square feet, and somebody could come in and say, let's split this one in half because there are going to be 10,500 each. So we'll put, instead of 2 homes here, we'll put 4 homes here. And I don't know, we can walk around the neighborhood and see if we get some more lots so we can at least have 16,000 square feet. We'll split those in half because it's, it's 8,000 square foot zoning. If you look at what the county does in that area, they build these monstrosities, which we all are opposed to. So that's a problem that I'm kind of wrestling with here. Secondly, it's somewhat, I feel somewhat unfair to the applicants tonight because they've gone through a lot of work and they've submitted plans that I think are dear to their heart. But when you go out there and you look at all the single-story houses, and when you look at their house, which is a single-story house, I think we at least will make it clear that if your heart is set on a 2-story house, you may not get it. So in how you configure the lot, one should not assume that you're going to get a 2-story house. I'm not saying you won't, but I'm just saying that we're not passing on that tonight. And we're, I think, going to ask, even if we do approve something, that it come back to this commission for architectural site approval. So as far as the 65 feet, foot lot, it is a problem. I don't begrudge the size of the lot. And the two conflicting policies that we have to deal with, that is to essentially make Los Gatos more hospitable to smaller lots, is probably a good policy. 65 feet is bigger than the 60 feet. But I am troubled if, notwithstanding Commissioner Kane's belief that we can operate without setting precedent, for the community, they tend to follow at least what the town council does, and some people may even follow what we do. And they say if you did it on one week, you might do it again on another week. And that would be a reasonable supposition. So I think we at least have to consider, are we very comfortable with this, and are we at all worried that it will be used against us, so to speak, just as Almendra was this evening, and no good deed goes unpunished. So I just throw those thoughts out for consideration. I'd like to hear where my fellow commissioners are coming from.
Thank you. Commissioner Bourgeois?
I share Commissioner O'Donnell's concern about the neighborhood compatibility of what's before us. I look at the applicant's neighbor and that large house that blocked your sunset, and if they're going up 2 stories, then they're just going to block their neighbor's sunsets, and it's a domino effect. They're going to go, we're losing the whole neighborhood. So I look at the findings that we have to make, and I can't make any of these findings to deny the subdivision. I've looked through all of them. They're within their rights. It doesn't meet any of these conditions, but I'm really concerned about the houses that are before us. That, I think we need to really impress upon the applicant that, at least for this commissioner, I'm going to want to see something substantially smaller and substantially within the character of the neighborhood. The houses that I see in front of me match the neighbor to your left more than anything else in the neighborhood. That's my take on it. So.
Commissioner Machici, and then...
I have a question of staff.
Okay.
The house sits between 16701 and 16640. Is that correct? These lots?
Do you mean in square footage or?
No, the
address.
16883 is the address of the existing lot, right?
Got the chart right here.
It sits between 16701
and 16640, right? Both of which are 2-story homes?
No.
That's what it says here.
16661.
The third one down on the other page, Phil.
I'm sorry.
One house is a single story, one is a 2-story. Right. On either side.
Oh, that's where it is. Okay. I had that wrong. Okay. Right. So that's some 2 families in there.
Okay.
Right.
So...
Oh, okay. I didn't see that.
Commissioners, I guess I'll chime in here. I'm looking at this and I'm seeing that there's going to be this one lot, which was probably one of the largest frontage lots on the street, is now going to be reduced to 2 lots with possibly the smallest frontages on the street. That to me signals a change in character of the neighborhood right away. If these are the heart desire of the applicant, the houses, as they're shown to us tonight, that also signals to me a mass and scale problem with the smallest frontages. And so I have to be comfortable with that lot line split. And from what I'm seeing, I'm not comfortable with it. I think it really is about, at this point, cutting into the character of the neighborhood. And it bothers me a lot. Although our goal here is to work with you and to, hopefully help you to arrive at what you would like. The obstacles I see at this point are neighborhood compatibility, streetscape harmony, and the rhythm of that area, and mass and scale. Now, mass and scale we can deal with through architecture sometimes. And I think as Commissioner Bourgeois was explaining to you, that could happen. On the other hand, you said in your letter that, you didn't want to have one big, large home built on that property. But actually, through the planning process, it would have to be in proportion to the homes in the area. So you're not always granted to have the largest home in the area. Anyway, and with that, that's all I have to say at this point. Commissioner Rice.
I struggle with this a little bit because one of my favorite perspectives is just because you can doesn't mean you should, or doesn't mean you will. But I'm kind of with Commissioner Bourgeois that I find it difficult not to find some reason not to approve it. That being said, I'm not sure the applicant hasn't done themselves a disservice by giving us maybe more information than we needed, because what we're seeing in the way of architecture for the houses is not before us. And we can give them all kinds of guidance of what they may or may not get, but the bottom line is...
Has nothing to do with it.
Thank you. It has nothing to do with where we are tonight. We're looking at a subdivision application, and we're going to require architecture and site to come back anyway. I want to comment that I appreciate staff bringing this to us as opposed to just dealing with it at DRC, even though they could have. I think that was a good call. I also want to maybe disagree with Chair Tallis for that while what we're looking at that we can't vote on or talk about tonight with the architecture may be out of character, I'm not sure that I see the subdivision itself being out of character with the neighborhood. So I'm inclined to support the subdivision, and then let's see what we can work with the applicant on when it comes to architecture and site.
Well, to follow up with your comment, not that I'm here to try to convince you of this, but what I meant by out of character is the lot frontage size would be out of character in that area, because it would go from one of the largest frontages to now the two smallest. So that's where I sat with that. And I could find under the State Subdivision Map Act, D, which is that the site's not physically suitable for the proposed density of the development, which is right on the cusp probably, but anyway. Commissioner O'Donnell, and then Commissioner Keen.
Commissioner Bourgeois, when he pointed us to the Subdivision Map Act, which is set forth in Exhibit 2, the sum and substance of it, I think does not give us wide latitude. So if any of my fellow commissioners believe that under A through G, they can make a negative finding, and D was just cited to us that the site is not physically suitable. I don't know what that means, but I don't think it means the nature of the perception of the nature of the neighborhood. I think it means something a little stricter, but I just say that if one says I don't like it, or I don't like the feel of it, or I don't like the character of the neighborhood, all of those things may have something to do with the ultimate building, but I don't think they allow us under the State Subdivision Map Act to prevent the lot line adjustment or the splitting of the lot. But as you pointed out, I think perhaps a commissioner could take one of those subsections. I'm just saying if we were to deny it, we should specify which one or ones of A through G we feel are not complied with.
Exactly. Okay. Commissioner Keen?
Well, first, an argument leading up to responding to Commissioner O'Donnell. I always feel it's awkward to do these things in two pieces. We're doing the subdivision, possibly hoping we get what we want on the A&S, but if we don't get what we want on the A&S, then we're going to wish we hadn't subdivided. I mean, that's putting it in plain English. Although there's no legal quid pro quo, that's what perhaps 7 of us are concerned with. And let me take a step further. The applicant might be concerned with that under be careful what you ask for. Because if you get the subdivision and then you end up with 2 one-story houses, you may not be happy. I wish there was a way we could put this together and just talk turkey and say, this is what we're concerned with, this is the power, this is the influence of neighborhood compatibility. If I had to find a reason for a State Subdivision Map Act refusal, it would be B, that the design or improvement of the proposed subdivision is not consistent with applicant general and specific plans. And I think the whole argument and philosophy is in Section 2 of the general plan under land use and maintenance of small-town character, maintenance of neighborhoods, maintenance of what makes the place special. And what makes the place special is not carving two long lots with two-story houses set front, as is the one to the right, which didn't happen on my shift. And that one to the right begins to change the neighborhood. And the problem with doing it once is it's going to happen 2, 3, 4, 5 times. And the problem with that is somebody's going to get their heart broken because it seems unfair. You've got neighborhood support, you've got this and you've got that. I've got language to protect the town. And that puts me in a real tough spot. I may be wishful thinking on talking turkey, but I just wish we could see the whole project. That Plan A is a subdivision with this and this, Plan B is no subdivision with this. And it's been said, but you need to know that more than one person thinks it, the limits of a given project are not targets. And if a lot is big and the houses all around it are huts, well, we're probably going to have a really fancy, elaborate hut, because that's neighborhood compatibility. I exaggerate to make the point. If you didn't subdivise, we're not going to put in the Gracie Mansion. So there's two ways to look at this, and I think there's plenty of protectionist language in the land use section of the general plan, protecting, as has been said, a domino effect. Because it's going to look like a good idea to other people. That'll change the character of the neighborhood, and we're sworn to prevent that.
Commissioner Micciche.
Yeah, I'm going to make a motion.
Okay.
I'm going to make a motion, we approve subdivision application MO7-144. We're not approving the architecture and site application.
It's only for the demolition and the subdivision.
Demolition, right, okay. However, as part of the motion, I'd like to add to conditions that both architectural and site applications come back to the Planning Commission. And secondly, we make a strong recommendation to the applicant as part of this motion that he really examine mass and scale and compatibility of neighborhood before he comes back with his final plans.
Okay, we have
I was going to make the cry fine, but if I get a second, I'll just continue on.
Oh, okay, go ahead.
We get a second?
I'll second for the moment. All right, we have.
I'll second.
Okay, I see the project is categorically exempt pursuant to Section 15315 of the State Environmental Guidelines adopted by the town. As far as the findings, number one, they are maintaining the town housing stock. In fact, they're increasing it. If you assume the cottage is not inhabitable. Preservation of historically or architecturally significant buildings or structures. There's none. Property owners desire to maintain the structure and the economic utility of the building or structure. Under the Subdivision Map Act, I cannot find anything that can deny this, so therefore, by default, I approve it.
Okay, I have a motion to approve, and I have a second. Do we have some discussion on this? And I have Commissioner Kane and anyone else?
Steph, may I?
Yes, of course.
Mr. Suda, I have an interesting question. Let's say that this motion from Commissioner Micciche, let's say it passed. Would the applicant then be bound by it, or could he later and or she say, well, we don't want that, we want it the way it is? Sure. Are we putting them into a corner if we pass this thing? Just an academic question.
Are they bound by your conditions?
The subdivision, yeah.
Yes.
So what are you saying?
Wait, so they cannot decide if we granted them the subdivision, and then they went away and thought, you know what, maybe that's not such a good idea.
Okay. That's what I mean.
Yeah.
Yeah, they're not
If
bound
you
by
approve
it.
the subdivision map, they are not bound to record a final map and officially record the subdivision at the county recorder's office. They can walk away and not subdivide the property.
I did not know. I wanted to clear that. My second point is I cannot support the motion for the reasons that I stated, that the subdivision is not consistent with the general plan.
Okay, do I have any other comments on this? Anyone, all right, Commissioner O'Donnell?
The only comment I have is that the problem we're dealing with is a problem that could be solved by an ordinance, which we don't adopt. We say this is an 8,000 square foot neighborhood, and then somebody comes in and says, great, I've got all this land, I want to have two 11,000 square foot lots, and we say, oh my gosh, don't do that. It seems to me if the town has a policy that basically says we really don't want anybody to make their lots smaller, I think the town should do something. That is not our job. We are not the town council.
I agree.
And therefore, if you live in this town and you say, what do the ordinances say? You say 8,000 square foot lots. Now, we've got, in this particular case, somebody saying, I'm not asking for an 8,000 square foot lot, I'm asking for an 11,000 square foot lot. It will never be split again because it can't be. And where we are is we can not like the way some of the things are going, perhaps, that's our perception, but I don't think it gives us the right to act as if we're the town council. And I'm afraid that we may have a tendency to want to do that in the desire to do that which is good. Maybe I'm talking to myself in part of this too, because I'm still wrestling with this. But I tend to think that he and she, both, they fit the state subdivision map act requirements. We're being asked to approve it unless it doesn't, and I think it does. We're not approving the houses. We can't tell them what to bring us back. They can bring back anything they want to. We can, at some point, say, we're not approving that, and it can be appealed, and the town council can do what it wants with it. So I think what I've heard so far is we don't like what they're suggesting from a density standpoint, so for whatever that's worth, you can take it and do what you want with it, but that's not before us tonight. So that having all been said, I guess all I'm saying is I think that under the Subdivision Map Act and under the laws of this town, they're entitled to this. And it's not a question of do I like it or anything else.
All right. Commissioner Bourgeois, and then followed by Commissioner Kane.
I have a question for staff, going back to Commissioner Kane's point about it'd be great to see this all together. I mean, an option for us would be to continue this and have it all come back with A&S. Would that be an option for us?
Under the timelines established by the State Subdivision Map Act, you must take action tonight.
Okay, thank you.
It's the final. Is it on this?
Yes, it is.
Okay.
Let me just tell you, once you approve the subdivision map and somebody comes in, same time, let's say, and we approve the house, okay, they record the subdivision map, they change their plans for the house, they come back in and say, we want to build this house, not that house. They've got their subdivision. I mean, it's like saying we're going to subdivide it, you're going to put a house up, 20, 30 years from now, they're going to tear the house down and put another house in. We have to say all we're approving is, are they entitled to the subdivision? We'll have to deal with the improvements if, as, and when they come across our plate. So I don't think it would be any great advantage tonight to have both of these things before us. It might save the applicant money to find out, but I don't think it speaks to the concern that some of us have.
Right. The only thing before us is demolition and lot line subdivision, and it's clear that they're within the codes of having this subdivision, barely, and then they'll just have to deal with the architecture and site. But to staff, we could require that the architecture and site come back to us with this.
That's part of the motion.
That was part of the motion. Thanks. See, I forgot already. Thank you. Commissioner Kane?
I want to disagree with Commissioner O'Donnell and use the same logic. This is a judicial board. We don't make policy. And to say that putting in two narrow lots, increasing the density significantly, arguably in some opposition to the general plan, that when all is said and done, we've approved the third and the fourth largest houses in the neighborhood, that of the 20 I looked at, 17 were one story, that the one that is larger than them it just seems to be a mathematical aberration. So we are changing the character of the neighborhood. The general plan says we ought not do that. And so to do otherwise is to set policy. Sometimes the judicial view is more narrow, But that is our job, to be judicial, not to be Solomon and set policy. I know it can disappoint people who have their hearts set. Our job is to judicially stick to the language, protect and preserve the town.
Okay, with that, I think, Commissioners, we've heard from all of you, and I would like to call for the question. So, all in favor of demolishing an existing single-family residence and dividing subdivision of 2 lots on property pre-zoned R18, please say yes.
Aye.
That's 3. And against?
3.
Oh, I didn't see. Would you raise your hand again, please? Okay, this is in favor of the motion. Would you please raise your hand at this time? Okay, that's 4. And those against? That's 3. So motion passes 4-3. Appeal rights?
This decision is appealable to the town council. An appeal must be filed in writing with the town clerk upstairs within 10 days. There is a fee for filing an appeal.
Okay, thank you very much. Commissioners, we'll move on to item 4.
I was convinced. What? I was convinced. That was not consistent with the general.
Which is architectural and site application. Excuse me, Commissioners. Architecture and site application S-07-199, conditional use permit modification application, Commissioners, U-07-156, and variance application V-07-145. Location is at 16565 Shannon Road. It is, applicant is Santa Clara County Fire Department. Property owner is Town of Los Gatos. And the application is to request to demolish an existing 700-square-foot training tower and construct a new 3,675-square-foot maintenance building. And a variance is requested to allow an 8-foot rear yard setback where 20 feet is required by code. APN number is 523-08-015. And with that, we will hear from project planner Curtis Banks.
Thank you, Chairperson Talas, for members of the Commission. As mentioned, this is a request by the Santa Clara County Fire District to construct a new 3,675-square-foot maintenance building and garage. The district is proposing to demolish the existing 700-square-foot training tower that includes a maintenance shop on the ground floor. That maintenance shop would be moved to the new building. There are no proposed modifications to the existing fire building itself. The new structure would house fire hoses, disaster preparedness materials, and homeland security equipment that's currently located in containers in the back of the facility. It would also include the maintenance workshop, office and bathroom for the maintenance worker. There would be a small storage room on the side that would house equipment used for pump tests that are performed on the site. The garage could be used for storage of department trailers and fire engines, but would note that the building would be used for storage only. There would be no maintenance of vehicles performed at this site. Construction of the new building requires a modification to the existing conditional use permit for the fire station, site and architectural approval for construction of the new building, and a variance to allow a rear yard setback of 8 feet where 20 is required by code. With respect to the use permit, staff is recommending approval. The uses that would be accommodated in the storage building already occur on the site, such there's no intensification of the site, with the possible exception in the future of one additional maintenance worker. There'd be no additional traffic generated with the new building. With regard to the architecture and site approval, the proposed storage building has been designed to complement the existing fire station building. The roof pitch, materials, and colors would be similar to the existing structure. The applicant has modified the design to incorporate suggestions of the consulting architect to lower the height of the building and provide roof overhangs. Staff would note that the height of the structure would be approximately 19 feet 10 inches, 20 feet, and the height of a building approved on the adjacent site at Shir Hadash is approximately 22 feet. Staff has included in the recommended conditions of approval a requirement to add some additional trees along the perimeter of the new building to provide some additional screening to the adjacent property. There is also a variance requested. Variances from the zoning code may be granted upon finding of fact owing to special conditions, and enforcement of the provisions of the chapter could cause undue hardship. The specific findings are identified in your staff report. Staff noted that the town does not have specific zoning requirements or regulations for public facilities such as fire stations. Instead, they are required to develop in accordance with the regulation of the zoning district in which they're located. In this case would be the R1 regulations. However, given the unique nature of public facilities, it is sometimes difficult to comply with conventional zoning requirements when developing a site. Given the unique nature and needs of the use, staff does recommend approval of the variance. The special circumstances are the location of the fire station in a residential zoning district and the surrounding quasi-public uses. The proposed building location is adjacent to Shir Hadash's parking lot. The location of the building would provide adequate necessary circulation for the site and also minimizes visual impacts to the surrounding residential neighborhood. The granting of the variance would not result in a special privilege because of the unique nature of the use that differs from traditional needs in a residential zoning district. So tonight, staff recommends that the Planning Commission take the following actions. Make the findings as required for the granting of the conditional use permit. Make the required considerations required for the architecture and site applications, make the required findings for the granting of the variance, and approve those applications subject to the conditions of approval. So that concludes the staff report and could answer any questions you may have.
Thank you very much. Do we have any questions at this point? You know, I have a question for why not ask this question, but and that is under unusual circumstances. If this building, the firehouse as it is now, and the ensuing building, perhaps it gets passed, if it ever cease and desist from being a fire station, what would happen to all of the all of the granting of anything, setback variances, et cetera, et cetera?
Well, the building...
because it's in a residential area is why I'm asking. Could that ever resort to being a residence? And if that was the case, would they be granted the same setback variations?
Well, the town owns the site.
Right,
So
I
the
know
fact
that.
of becoming a residence is unlikely, and if the town ever, if it was decided that there was no longer the need for a fire station there, and the town sold the site for use as a residential lot, which are, I think, all unlikely circumstances, I would imagine that building isn't suitable for residential use, and somebody would need to tear it down and build a residential structure, and then that variance would go away.
Okay, that's all I wanted to know. Thanks. All right. Question, Commissioner O'Donnell.
Yeah, this is a question of Curtis. Would you explain once again why the variance is applicable? I'm looking at the drawings and everything. And would you explain to me again why the variance would be proper?
The justification in staff's viewpoint is the development standards in an R1 zone are designed for homes, residential uses. Public facilities such as fire stations are allowed in the zone with approval of a conditional use permit, but given their unique needs, which differ significantly from that of a single-family home, and the fact that the town does not have specific provisions, which some communities have different provisions for public facilities. Staff found that it was justified to grant a variance for this type of use and for this need.
Well, just remind me, put it another way, why is it that it couldn't have more than 8 feet?
Well, to have more than 8 feet, could it have more than 8 feet? Possibly. You would have to most likely reduce the size of it to some degree. They do have to allow adequate circulation around the building. So I think to get for their needs, given what's there, it would be, I think, a challenge.
Did anybody, I mean, somebody must have, when in selecting the lot and saying we only need 8 feet, somebody must have made a judgment that if we have more than 8 feet, there's a reason. Now, you're telling me what maybe might be and must be. Maybe the applicant will tell us. Why did I defer till he gets here?
Sure.
Obviously, there's got to be a good reason why they only want 8 feet, and I just wonder what it was. And I don't think it's a good one to say it's a different use, because the setback not only affects this property, but it affects the adjacent property. But I'm getting hands out there, so I think I'm going to get an answer. So let's wait for that.
Okay, Commissioner Kane, you have a question of staff?
Mr. Banks, did we hear anything from Temple Shir Hadash?
No, we have not.
Nothing pro or con?
Correct.
Thank you.
Okay, Commissioner Sayak.
Mr. Banks, is the maximum height 20 or 30 of the proposed building?
The maximum height of this building would be just under 20 feet.
1910.
1910.
Okay.
1910. Because the staff report says 30.
Right.
That may be what the commissioner is referring to.
Okay. I don't see any other questions, so with that, I'll call the applicant up. Is that Steve Jacobson? Oh, all right.
He's not getting up.
You're not getting up, all right. Would you please, you filled out a form, would you please state your name at the podium for us?
Hi, I'm Don Jarvis. I'm the Deputy Chief for Support Services for the Santa Clara County Fire Department at 14700 Winchester Boulevard. I think it might be helpful to you to understand what's driving this project. And it's not the fact that the old training tower is an eyesore. It is, in fact, an eyesore, and it probably has been since the day it was built in the early 60s. We have never addressed that before because, frankly, it wasn't in our way, and we were getting some use out of it by using the bottom floor of it as a maintenance shop. What drives this project is our need for additional space because our world changed after September 11th, and we've received lots and lots of federal directives and lots of federal money to purchase additional homeland security supplies and equipment. That has led to a proliferation of trailers. So if you looked at the lot, it looks kind of like a used trailer yard. And frankly, we need a place to store that equipment because it's valuable and it doesn't weather well. So that drove our desire to tear down the existing training tower, put up what is essentially a large garage to house this new specialized equipment that we've acquired over the last several years. Yes, sir.
Yeah, I have a question.
Yes, ma'am.
May I ask my question? And that is, I was out there today, and I saw that there were vehicles backed into some of the bays of the story pole building.
Yeah.
Is that what you're talking about with trailers, or is that in addition to trailers?
That's just because we had to park those fire engines someplace for now because we're actually selling them. They're for sale if you're interested.
Okay, so
They're for sale.
exactly why I wanted to talk to you. Could mine be red, though? Anyway, what I wanted, so they would not be in there, but when you speak of trailers, what do you mean? What's a trailer? What's it?
A trailer,
What do you
like
mean? That gets hooked onto the back of a fire truck?
Yeah, we had to actually buy a new truck to pull the trailers. So we have trailers that, for instance, one of our trailers has mass decontamination supplies.
Okay.
So if someone dropped a dirty bomb, We bring this trailer out, and it has all the supplies necessary to decontaminate 1,000 people.
I see, okay.
We have another trailer that has mass casualty supplies. So if a bomb went off somewhere and there were many injured people,
That's
we'd
not-
bring this trailer out. So
Not putting you-
we never had these before. We never
Right, we
envisioned
never,
the need for
right,
them.
exactly. Okay, well, that's interesting, I didn't know that. Commissioner Bourgeois, followed by Commissioner Kane, and then Commissioner Sayoff.
I have two quick questions, if I may. First of all, the use of the tower, so it hasn't been used as a training tower, so you're not losing a use that you need on site.
That's correct.
Okay, thank you. And then secondly, so are there going to be fire trucks parked in those bays at all, or not?
Well,
Is it all going
I
to be
can't
trailer?
say never, but our plan currently is for that building to house trailers and specialized equipment, not fire engines.
Okay, and when I was on the site this weekend, looking at that 8-foot setback and the request for variance, it seemed to me that you need some sort of turning radius to get out of those garages. Is that what's driving the setback from?
That is exactly it. And it's actually getting back into the garage. Because if we didn't have the ability to pull behind the station and then in, we would have to back in off of Shannon Road, which would disrupt this traffic flow, and we really, frankly, don't like backing up. We tend to hit things when we back up.
So do I.
I'm sorry. Commissioner Sayoff.
Is it Commissioner Kane?
No, I'm sorry, was it Commissioner Kane first? All right, I'm sorry.
Okay.
Sorry, Commissioner Kane.
Has any attempt been made to contact the temple or your other neighbors?
I can speak to that. I'm Greg Stowers. I'm the project architect.
Okay, is this part of our 5-minute presentation? Oh, we're on the question thing. Okay, so, but you,
As the project architect that was recently in front of you for Congregation Sher Hadash project, I have emailed all of these drawings to the entire building committee for that project, as well as the rabbi and the executive director, and have reviewed the plans with them. And over those meetings, there were no concerns raised from Sher Hadash.
Any support?
They didn't. Basically, their one concern was really landscape screening on the back fence, and we talked about, in working with staff, that we were talking of additional trees across that back line, and that was really their only
I stood in the parking lot today, and as the congregation comes, the whole hillside, center vision to the right, the whole hillside is gone. And just wondered if anyone had commented about that. Okay.
all of their comments that they were thankful that the training tower was coming down.
Second question, there's a station in Campbell. As you're going down Winchester, you make a left-hand turn before you get to the overpass?
On Sunny Oaks Avenue, yes.
Yes. And that station has a building that might be similar to this one, where it's multi-purpose. They could put an engine in there, or tons and tons of supplies. Or, in November, they put in tons and tons of Toys for Tots. Will we be able to do that in the future?
We already do a Toys for Tots for Los Gatos. So where that happens, it actually depends a lot on who the individual is who's driving it. So our crew at Shannon Station is very active in the community, so I would expect that around Christmas time, you will probably see a lot of activity.
All that new space looks a lot like the Campbell facility, better than what we've done in the past. The third thing is, I sort of support the idea, currently support the fire. I live at 493
Let me write this down.
Woodland Avenue, and
okay.
Thank you.
Commissioner Kane. Do I have any other questions? I have a question.
I was going to say, if I could also directly address Commissioner O'Donnell's question on the setback. We did a very detailed traffic pattern study. There's actually kind of two uses that were driving the location of the building. There is a pump station located right on Shannon Road, or Cherry Blossom, which is actually a big concrete pit, where the engines pull in and they test their pumps on the rigs just to make sure that they're working. And the biggest rig that the district has is their ladder truck. And so we actually figured out the traffic pattern to get that ladder truck into the site to be able to test the pump on that station. So that turning radius kind of drove really where the building could be. And then, so that pushed the setback. And then the depth of the building was really to allow for apparatus to be parked in the new building.
Thank you.
Okay, thank you. Commissioners, do you have any other questions? Don't see any, and I would like to thank both gentlemen for presentation. Thank you. I will close the public hearing then and turn this over to commissioners for discussion, a motion, questions of staff. Commissioner Rice.
I'm going to make a motion.
Whoa.
Move that we approve architecture and site application S-07-199. I think we're recommending, now we can just approve the CUP modification. Okay. U-07-156 and variance V-07-145. I can make the findings in interest of expeditiousness, referencing Exhibit 2. Attach the conditions as per Exhibit 3.
I'll second. Thank you very much. And Commissioner Bourgeois had his hand up. I'm sorry, Commissioner Kane.
Yes, he did.
Yeah, he did before you.
I'd like to second that, and I'd like to make one comment, however, on the variance application, because I concur with Commissioner O'Donnell. I don't find a lot of merit in the argument that just because it's a public use in a residential zone that automatically should get a variance. I think we've heard evidence that there is a very good reason for this variance, and so but I'd like to make that variance on those grounds that we have to facilitate traffic flow and not because it's a public use in a residential zone. So I just want to make that clarification.
Well, and because we don't have anything that's code for this and we're having to make the variance, perhaps can we put that in to the...
I'm fine with that being a part of the motion.
Could that be part of the motion? Would that be, all right, Commissioner?
Well, I think that just has to be the finding.
The finding? Or
that's how we're making the finding to make the variance.
All right, then let's do it that way.
If that's the motion, then that's my second.
Okay. So we have that clarification, Mr. Suda. Thank you very much. I think with that, we all understand the motion. Does it need to be repeated? No. Okay, I'm going to call the motion then. All in favor?
Aye.
Aye. Opposed? Nay. Motion passes 7-0. Thank you very much. Thank you, Mr. Banks, for your presentation, and thank you, gentlemen. Commissioners, we are at 10 to 10. This is amazing. We're going to be... Okay, so we have a report from the Development Director. Mr. Suda, do we have anything tonight?
Real quickly, at the request of Commissioner Vice Chair Kane, who's been asking for this for months, and we haven't adjourned before about 11:30 recently, just wanted to report, and I think many of you may have met these two planners already. We do have two assistant planners that have been added to the staff within the last 3 or 4 months. One is Jennifer Savage, who comes to us from the county of Monterey. And the second assistant planner is Marnie Mosley, and she's a resident of this area. She was a planner in Laurel, Maryland, and has relocated back home. So they joined us 3 or 4 months ago, and if you haven't met them, feel free to stop by.
Right.
Have we lost anyone?
Wait a minute. Commissioner Kane, your question was, have we lost anyone?
A number of months ago, two planners, Elizabeth Pettis and Guido Persconi, left the town.
Thank you very much. Commissioner
I just want to
Chichi and
understand,
then Bourgeois.
is there any movement towards having the council relook at the demolition aspect, where we state that the house has to be similar in construction? Would they this seems to come up every time here. Could we put it on their agenda to relook at that policy and see if they can come up with something a little brighter and intelligent?
I would think we could. The one thing we would have to do, though, is to actually do some maybe real reasons as to why. We'd have to do some research. We'd have to do a paper or something.
2 points.
Whatever it takes.
Okay.
Excuse me, we discussed that.
O'Donnell?
Yeah, we discussed that. I'm trying to remember, I think, John, you were probably there. We discussed it out in the lobby, and the council shared with us, as I recall, their interpretation of that, and they said, you weigh that, that's merely one of the things. And if the other things are there, it will trump that. And that's what they said. But the point is, some of us do not believe in what is called judicial gloss, which means that when a court interprets a statute, that's the way the statute's meant to be read, notwithstanding that it may not say that. And here, we read it literally, and we say, well, gosh, it means something else. And they say, wait a minute, we interpret that to mean you balance it. As far as I'm concerned, since they adopted it, and they're telling us what it means, I'm perfectly happy to live with it. But if somebody wants them to put it in writing or something, I guess that's another issue. But that's what they said to us.
Well, it still comes up, though, Tom, that's why I'm...
Yeah, but once they told us, what else can they do?
Well,
it's come up after they told us. Let's put it that way.
so
some of us don't change very easily.
So perhaps if, where would you like to go with this? Would somebody like to attempt?
Well, I'm asking staff, if the fact is it did come up again after they did tell us that. In fact, they told us that 2 years ago, and they told me that 4 years ago. But
make a suggestion?
It keeps coming up year after year.
Can I make a suggestion? Before you make a recommendation of any sort, can you give staff an opportunity to look back at the record of comments and the context in which those comments were made by council? It may very well be that they're in
the form that it's always
in the form of a decision that was made that can be referred to more specifically.
Okay, thank you. Yeah, that'd be fine too. Yeah, as long as we don't have to keep hearing it, right?
The second thing is that that's one of the policies that the commission or the council has raised as needing further clarification in the general plan update.
Right. Okay. So that will be handled at that point. Do we need to do it sooner than that? But on the other hand, it would be maybe helpful if there were some past, hearings that. Okay. Would you take a look at it? Thank you, Commissioner Bourgeois.
Commissioner Kane, were you on the same item? Because I'd like to bring up another item.
No, I thought we discussed it last week, and I asked if it would be clarified in the residential design guidelines, and I thought the answer was yes, Mr. Suda.
What's being clarified in the residential design guidelines is how the council and then the commission will view compatibility, what the definition of neighborhood is, and what is the definition of compatibility. So those are some of those things you'll be looking for when we review the residential design.
But demo per se will not be in the new guidelines?
Not directly.
Thank you.
No. Commissioner Bourgeois.
I'd like to...
Mr. Suda?
Yeah.
Do you have a question of Mr. Suda?
I have a question of staff.
Okay.
I know the town has adopted a revised, pre-approved tree list for the town 3-4 years ago, and we consistently see landscape plans that looks like they've never seen it. So I would just like maybe some clarification on the purpose of that tree list. Maybe it's not for planning. Maybe it's for... seriously, I
believe it's street trees.
No, it's also... well, maybe. I mean, that would be a good question to answer, because there's a ton of trees on there that are not appropriate for street trees. I mean, it is half native, half of which would never survive as a street tree. So if that's a street tree list, then it doesn't make a lot of sense. And I believe when we were developing it, the purpose was to give a broader option when people were coming in to Parks and Public Works for replacement trees. And I understood the intent of the new list was to also kind of direct landscaping, because we have these policies about drought-tolerant landscaping plants, but we had no native trees on our approved tree list. So I'm confused as to the purpose of that list. So maybe if we, at some point, we could get some clarification back on that.
Can you clarify that off the top of your head, Fletch? Okay, we will take a look at that list.
Okay, and then report back to us. Thank you very much. Anything else, commissioners? I don't have anything. We had a report from the development director, so I adjourn the meeting. Happy Valentine's Day.
Happy Valentine's Day.